What's going on, everybody? Welcome back to the LTL podcast. It is September 27, 2023. We're back here for another live show. The show is live right now, and if you're hanging out in the chat, feel free to chat on the right-hand side of the chat. And if you're watching this on replay, make sure once it posts to go down there in the comment section and give me a hashtag replay to know that you are watching this on replay. Tonight, we are continuing to to go through our coverage of the Karen Reed murder trial. And I did an extremely deep dive into this case today. And I'll tell you, I had a lot of questions. There's a lot of concerning things in this case. I was actually back and forth with one of my moderators today in email, and they were kind of giving me some information to look into and some things that they found to be a little strange in this case. And I don't know. I'm very conflicted. I was supposed to go out to the area. I was supposed to go out to 34 Fairview Road today. Unfortunately, I apologize. I got tied up doing some personal things, but I'm going to make that happen tomorrow. And I think it was better that I didn't go there today because I wanted to read a little bit more about this case, what's going on. There's so much about it and there's so much elements behind it, but I wanted to look at it at an evidence. Just look at the evidence and look at the argument today. And I don't want to get into the supposed corruption, the alleged corruption. I'm trying to keep my mind straight and leave all of that out of this. Now, I know this is an extremely, extremely, extremely sensitive subject. And I'll be honest with you, my friends, I may lose some people on this. I want to make this very apparent and clear as well, too. LTL Podcast supports law enforcement. LTL Podcast supports people that come out and help our community. But if there is any type of corruption in this case, the bottom line is this: John O'Keefe, a Boston police officer, died, and we need to find out what happened. And I'll be honest with you, my investigation today, reading through some evidence, looking at the argument, it left me very conflicted. It left me very conflicted in my discovery. Now, this is only my opinion, and I'm going to give you a little bit of stuff today to look at and some things to think about. And what I'll do is I'm going to go up here and post the PCA at the top of the chat again, because I think it's important that when I give my presentation tonight, that you can go back and refer, do your own investigating. So let's do this. I'm going to pull up some things that concern me, some things that I have a lot of questions about, and then we're going to play Karen Reed's formal charges, so her first appearance in court, and then 2 motion hearings. There's one other pretrial motion hearing that just happened just over a week ago. And I plan on coming back tomorrow night because that's a 2-hour motion and play through that entirety. This is a very important case. It's very important to me because it's happened in the great state of Massachusetts. I know law enforcement officers in Massachusetts. I trust law enforcement officers in Massachusetts. But if something's going on, it needs to be found out and we need to get to the truth. And if Karen Reed did this, then she needs to be held responsible. But if Karen Reed didn't do this, then the person or people that are responsible for this need to be held accountable as well too. And that's where I don't want us to lose sight. Now, there's certain people out there that are going up about it in a certain way. I'll go about it in my way and try to keep this, true to LTL podcast, the style that we have investigated cases, the style that I've put information out there. But I'm again, my friends, I'm really, really conflicted about this case now. So let's do this. I'm going to pull up my presentation. We're going to look into this. And I think this is an extremely important case for everybody to get into. I'm trying to get some eyeballs on this case. I want to know, and I want everybody to know about it. I think it is just as important, if not more important, and I don't like to say that over specific cases that we cover, but probably just as important as the Idaho case. There's a lot at risk and there's a lot at stake here. So get your eyes on this case. I'm going to be covering it for a while here on LTL. Come in and join these lives. Check out what's going on. Do your own independent research. All right, let's pull up this presentation. I just want to welcome everybody into the live chat. My moderators, my members, thank you for being here. Thank you for being here. All right, let's look at my short presentation and then we'll start getting into the hearings this evening. I'm not going to be able to see the chat as I present, but feel free to chat away. And I'll do my best here to okay, hang on. Okay. All right. So we are looking at the Karen Reed case. Karen Reed has been accused. She's a Mansfield, Massachusetts resident that has been accused of driving over and killing her boyfriend, John O'Keefe, a Boston police officer. And this happened back in January of 2022. So Karen Reed has been charged with second-degree murder, motor vehicle manslaughter, and leaving the scene of a collision in connection with John O'Keefe's death. Some key players on the defense side, you're going to see Alan Jackson, high-powered attorney from California. He's very well known for his understanding of cast information. Karen Reed there in the middle of her attorney, and David Yanti. You have Officer John O'Keefe. Okay, here's some things that really bother me about this case. I'm going to be right up front with you all, my friends. Here's some things that really bother me. 5 people in the house never interviewed and cell phone records never looked into. That bothers me. Police never taped off the crime scene. And then Brian Alberts, the owner of the home at 34 Fairview Road, never comes out during the entire investigation that evening and that early morning. Why? The thing that I just find odd is that, and I was actually talking to my mom about this today, I think that's very odd in the sense of if I live in a residence and there is a dead body on my lawn, why would no one come to my house and knock on my door and say, did you see anything? Did you hear anything? No statements were taken at the time of the discovery of the body. That bothers me. That's weird. Sloppy police work? I don't know. It's very interesting. Some other things that bother me. Right after, not too long after Albert's family sell the house, the night of the incident, Alberts had a German Shepherd. After the incident, the Alberts sell the German Shepherd. Now, this German Shepherd, from my understanding, and there is actually documentation that you can look up, that this dog has been uh, in 2 other incidents of biting people. A very aggressive dog. Dog's gone. No one knows where the dog is now. That bothers me. It's interesting. John's Apple Watch, his health data suggests that he traveled steps away from the SUV and into the house up 3 flights of steps. Or up 3 flights. That house has 3 flights inside of it. That bothers me. Some other things that bother me. At 2:27 a.m., Jennifer McCabe, a person that was inside that home, Googles, and she spells it wrong, house long to die in cold, hours before calling 911. Why? John's body shows no signs of being ran over, no bruising, no tire marks, no broken bones besides skull fractures. Now, if you go back and you look at the Boston Bombers, when they were running havoc all over the city of Boston, one of the brothers ran over his brother in an SUV. In that SUV, after you ran him over because they were running from the police, he literally had a cave-in mark on his chest. You could see that his body had been run over. His whole body was burnt, was tire marks on it. I don't know. That's just it. There's something that just bothers me. John's injuries, in my opinion, are consistent with a fight. Bruising on the fist, like a boxer's fist injury. 2 black eyes, skull fractures, scratches on the arm. No scratches coming from the defense say that it looks like superficial wounds from like dog scratches. Witness states that they only saw Karen inside the SUV when they drove by the house and didn't see anyone else or near the SUV when they left. So that would indicate to me that John had to be inside the house. This one is nuts. And I'm going to show you this. The state now says how John died was the state says Karen backed up, and this is the state, backed up 62 feet at 24 miles an hour in a blizzard and hit John. This was the conditions that night, and I'm going to show you the video. If you see that red arrow, that's the flagpole that's inside of the house. His body apparently flew over the snowbank after being hit with all this snow in the way, 12 feet, and landed over that snowbank. That bothers me. So I'm going to show you something. Let me just stop this. Let me bring this up here. I just want to get to this. I think I saw a super sticker come in. Diana HB with a 199. Thank you so much. I appreciate you. Let me just try to keep getting through this presentation. Okay, let me show you some video from that night that was shot on scene. And then I want to play you a recreation of the backup. Okay, let's play this. This is from the video from that night when John O'Keefe was found.
Backing her vehicle into him in January of last.
This is that night. This is the weather conditions that night.
Year, his body discovered in a pile of snow outside the Canton home of a fellow officer who hosted a gathering there. Defense attorneys have raised a theory that O'Keefe of snow outside.
There's the flagpole. Look how deep the snow was. Let's just even say there was a surface layer of snow on the ground. I'll give you that. Let's just say this snowbanks weren't there. Just a surface layer of snow. Keep that in mind. Backing up 62 feet in a blizzard at 24 miles an hour. I'm going to tell you, I've lived in New England my entire life. There's no fucking way, and I'm sorry, there's no fucking way that you can get in your car in a blizzard and back up 62 feet, point on blank, in snow at 24 miles an hour. I don't even think that I could do that in clear weather. Straight back. And then someone's going to stand there and let a car just hit them? Doesn't make sense to me. I'm sorry, friends. You know, I might put some stuff out there that might upset some people. This bothers me, though. It doesn't make sense to me. So let me play you this. Here's a recreation of the backup. And nevertheless, the road is curved. So to me, it would make it seem, now Karen Reed had never been to that house, never been on that street. She shows up in a blizzard. The state is saying that she backed up 62 feet in a blizzard, hit him at 24 miles an hour. His body flew 12 feet. She's never been on that road, and the road curves. She would have to be a master driver. And in my opinion, John O'Keefe would have to literally just stand there and let him hit her, let her hit him. I don't know, my friend. I mean, this is just things that I'm thinking about. I could be wrong. I could be wrong in this. And I know I'm going to probably say some things tonight that are going to piss people off. But what I'm trying to do is keep my head straight and clear of what I'm seeing here. It doesn't make sense to me. Let's watch that recreation.
So look at, this is where, so Karen, so okay, we marked 62 feet off, right? Mm-hmm. So that's where Karen Reed started. That's where the back of her car started, okay? And you see the line down there, the other line, that's where he got hit, okay? So, I mean, that's 62 feet. So we have to believe, right, that the freaking car that...
Now, keep in mind, you can see the curve of the road. I'm going to go down there tomorrow. You can see the curve in the road.
First of all, it curves. Notice how the road curves? So I hit the bumper. You guys can see down there.
Clear conditions here, too.
The mark, I hit the bumper the first time I did this. I reached 14 miles an hour the first time I did it. I just did it again. I got up to 27. No, I apologize. 17 miles an hour, right? I got up to 17 miles an hour.
In a blizzard in New England. I've lived here my whole life. There's no way that someone could get in their car, mash the gas, and get up to 24 miles an hour. And the road, to me, right here, just at this angle, looks like it's on a grade. It's actually going uphill. When I saw this kind of did it for me, because when I was scouring all the video today and going through and looking through this and putting this together, I'm looking at it and I'm going, all right, I need something. I need something here that's gonna make me really think about this. And then I saw the video and the conditions that night. And I went, holy shit, there's a ton of snow on the ground. And me knowing that I live here in New England and driving in snow my whole life, how treacherous it can get, especially in blizzard whiteout conditions. And then going back and look at the scene, and I'm going down there tomorrow because I want to see for myself. It didn't make sense to me. It didn't make sense to me. All right, let's keep playing this.
Now, that lady yelling at us. And then,
and if you've
but 24, man,
road, if you've even backed up at a high speed, it is pretty weird because you're kind of doing this.
I mean, when I went from 14 to 17, I was a big jump. 24, it curves. Like, I hit the fucking curb. There's no way if she, so let me guess. Go stand down there, like where John was. So, like, just, so Richie's John's height, too. right? So she drops him off, right? And then for some reason he stands there in the middle of a snowstorm. He just stands there. And Karen pulls up here. She gives him time to, because he's all mad and she wants to kill him. And what? Hey, John, I want to kill you. I fucking hate you. Can you just stand right there for like a minute so I can pull forward 62 feet and then gun it in reverse? And then the car's coming at you. And so the car comes back here, right? She somehow, I don't know, she doesn't turn because they didn't say anything about any tire marks on the curb. I just made tire marks on the curb. Look at this shit.
There's no way.
So John,
there was snow banks there that night. This was all covered with snow. There's no way.
Standing right here where the car comes back and he just doesn't go in. Like, why did she drop him off right here? We've been over this. Why did she drop him off right here and not in the driveway, right? And he just stands here and he's like, yeah, just hit me because I feel like dying today. And then again, see this right over here? Those are my tire marks because I didn't turn it. I didn't turn the wheel. So I hit the freaking curb. So Karen's car is a tank. So she hits him, right? And somehow his body goes that way. Maybe he tried to get out of the way, because that's what they're saying. And they just knock it that way. And then, so then what? How does she not run him over? Like, so it also.
I can guarantee you, even if you want to say there was 2 inches at that point, I have lived in New England my entire life. I have driven through many snowstorms and blizzards. I'm telling you to get in your car and mash the gas and try to drive a straight line up a curved road in 2 inches of snow is almost impossible. And she was inebriated. It doesn't make sense to me. It just doesn't make sense. The state saying that doesn't make sense to me.
It says it keeps going. So she hits him with the back of her car, with the right back of the car. That's how far away it is, right? And just boom, hits him there. How the hell does he get the head injuries?
And the arm wounds, right?
And the arm wounds. It's all grass.
He ran him over, but the undercarriage got him. But it couldn't, according to this theory, he just go there flying. You know?
Yeah.
Shoe comes off, hat comes off.
Yeah. How do you get the scratches? How do you get the scratches that way?
Dog bites.
The dog bites, whatever. Oh no, whatever. The abrasions, I'm not a medical examiner, so what do I know? But that's fucked up. So we're gonna try it again. We're gonna try doing this one more time. You want to do one more time?
Yeah.
Let's see if we can reach this time. Let's go.
Done it.
Can you hold my camera too, or is that too much to ask? Okay. It's still taping, so.
All right.
There we go.
All right, so he's going to back up here, and now clear road conditions, no 2 inches of snow on the ground, no snowbank. And he's going to give you an idea of a clear day drop backing up. And you see the road, it's curved here. And this is what the state said happened. 62 feet out at 24 miles an hour. This is what it somewhat would look like in clear conditions.
I hit 19 miles an hour there. That was pretty, that felt fast as shit.
Yeah.
I'm not gonna lie. That was really fast. So, again, I don't think I could have gone above that. That was literally as fast as I could possibly go. And I felt like I was dying. Like there was there was fucking like an amusement park ride, except it's like real life. And she fucking give me a break. Here's a fucking joke. So that's fast. First of all, think of how loud that was fast, right? Yeah. Like that seemed fast. So
that seemed really fast.
Yeah. Okay, guys. So we'll see. We got some more testing out to do.
All right. That's from Turtle Boy Live. And he has been mashing content about this for the past 6 months. This case has essentially been his life. He's an award-winning journalist here in the state of Massachusetts. I've been reading through some of his blogs. I've been reading through a lot of the news articles. I've been looking through video. I've been reading the PCA. I literally read the PCA 4 or 5 times today. That's how I came up with all my issues that I have in this. That's some things that have just really bothered me. And then when I saw the video of the conditions that night, I went, there's no flipping way. And then the state now coming out and saying 62 feet in front of the house, backing up at 25 miles an hour, hits John O'Keefe. His body flies 12 feet in the air over a snowbank. And it must have been perfectly lined up with 2 inches, 3 inches, 4 inches snow on the ground in whiteout conditions. That's kind of where I started to question a lot of this. That's where I really started to question a lot of this. All right, let's get into the first appearance for Karen Read in court when they read her formal charges. And then we got 2 other hearings, pretrial hearings that we're going to go through as well. Hang on one second. Here we go. Here's the first
vehicle, one count of leaving the scene of personal injury and death. These offenses taken place January 29th, 2022 in the town of Canton.
Good morning, ma'am. I'm advising you pursuant to Mass General Laws, Chapter 276, Section 58. Should you be charged with a crime or violate a release condition while this case is pending, you could be held in the House of Correction for up to 90 days without bail. Good morning, Mr. Netti. Good morning, Mr. Lely.
Good morning, Ron.
All right. Mr. Lely.
Your Honor, with the court permission, could I just pull the mask?
Yes. Yes.
Thank you, Your Honor. Your Honor, Adam Lally for the Commonwealth. The Commonwealth is requesting that the court set a cash bail in this matter in the amount of $50,000 with some additional conditions. Those conditions being the bail warnings as just read by Your Honor to the defendant, as well as conditions that she stay away and have no contact with the deceased victim's family, that she stay away and have no contact with the deceased victim's residence, and that she be prohibited from operating a motor vehicle during the pendency of this case. In support of that request, Your Honor, the Commonwealth would cite the nature and circumstances of the offense, as well as the potential penalty that the defendant.
Do me all a favor. Just make sure that you hit the like button when you come in. We got about 83 people in here. Let's get this case out into the algorithm. YouTube constantly suppresses my channel. They don't want this podcast to live and breathe because we put relevant, good information out there. And I'm seeing now that I'm following this case and talking about it. My channel's become more and more suppressed. I'm not going to follow YouTube. I will continue to keep pushing and talking about this case. The minute I go live, they limit me right away. I have to fight to get my monetization on this. I have to fight to get this out into the algorithm. So it's super, super important that you're all here in these live shows. Smash that like button. Let's get up to 100 likes tonight. Let's prove that algorithm wrong. They don't like LTL podcast because we put out the real truth in cases. I don't fall into conspiracy theories. I investigate and put information out there that I only would feel good about at the end of the night, laying my head on my pillow and going to sleep. But YouTube wants to suppress this channel. YouTube doesn't want this channel to be pushed into the algorithm, but we'll show them. All right, let's keep playing here.
Faces, particularly with reference to the manslaughter charge and the leaving the scene of personal injury and death, the latter being...
Oh, by the way, I had conversation with Turtle Boy today. I'm working on getting him on the podcast. We're just trying to line up a date and a time. It's possibly going to be sometime next week. Him and I were kind of chatting through email earlier this afternoon. He probably fell in and got busy, so I'll look forward to his email tomorrow. Hopefully we line up a date and time next week. We'll have him come on because he's done about 6 months of investigating on this, and I want to hear it from him. He's really been the rally cry for Karen Read. He's really been the one that's been out there for, investigating on this, getting it out there in the public. And I'd love to hear you know, what he has to say about this. So, you know, we'll keep playing through here.
Bind over. The facts of this case, Your Honor, essentially on Friday, this past Friday into Saturday, January 29th, at approximately 6:04 a.m., the Canton Police Department received a 911 call from a woman reporting a male party subsequently identified as the decedent and victim, Mr. John O'Keefe, who was found in the snow at a residence on Fairview Road. At the time of the 911 call, there was heavy snow and the temperature was in the teens. Officers Saraf and Mullaney of the Canton Police were dispatched to the scene along with Canton Fire and EMS. Officer Saraf was the first to arrive on scene and observed 3 females waving at him. If you were standing on the roadway looking at the property, the 3 females were in the left corner of that property. Officer Saraf observed the victim lying on the ground as 2 of the females were performing CPR. The 3 females on scene were subsequently identified as the defendant before you, Ms. Karen Reed, Ms. Jennifer McCabe, and Ms. Kerry Roberts. Officer Saraf observed the victim to be cold to the touch, no signs of breath, and returned to his cruiser to retrieve his AED device. At this time, Canton Fire and EMS arrived on scene and took over first aid. Paramedics then transported the victim to the Good Samaritan Hospital in Brockton, where he was determined to be deceased several hours later. Several detectives from the Canton Police arrived on scene moments after the 911 call. They began to search within the snowbanks for any evidence, at which point they discovered a broken cocktail-style glass and multiple patches of red substance that appeared to be blood in the vicinity. They secured the glass and 6 blood samples from that area as evidence. Troopers from the Norfolk County District Attorney's Office, specifically Sergeant Buchanan and Trooper Proctor, then arrived at the scene and began the process. They also spoke to several witnesses. Specifically, they spoke to Ms. Jennifer McCabe. She stated that the evening prior, she and some friends were at the Waterfall Bar.
Feels good, Sam.
Located
Thank you.
within the town of Canton. She stated she and her husband arrived there at approximately 9 p.m. At approximately 11 p.m., the victim and the defendant arrived at the Waterfall Bar together. She indicated to the troopers that the victim and the defendant had been in a dating relationship for the last 2 years, and that the defendant often stayed at the victim's house most nights, is what she described it as. She observed the defendant walk into the bar holding a glass cup from C.F. McCarthy's, which is a bar located across the street from the waterfall, with a clear liquid inside and what she believed to be a vodka soda drink. She observed the victim to be wearing a baseball hat, jeans, and sneakers. The victim and defendant had been at C.F. McCarthy's across the street before coming to the Waterfall Bar, as I stated. She stated that the victim and defendant appeared to be in a good mood, did not observe any arguing amongst the two, described the atmosphere within the bar as friendly amongst the patrons. She indicated as the bar began to close down, everyone was invited back to that residence on Fairview Road. She observed the defendant and the victim leave the Waterfall Bar together. As the group was exiting, the victim texted Ms. McCabe, where to, at 12:14 a.m. She replied with the address on Fairview Road. At 12:18, 4 minutes later, the victim called her to ask where specifically the house was located on Fairview Road. While inside the residence, she observed a black SUV arrive in front of the residence on Fairview Road. She observed this from the front door. She texted the victim at 12:31 a.m., hello, and at 12:40 a.m. texted
Mary, what I was getting back to you about, you said great email, by the way. What I was getting back to you about was the video of the conditions that night and them talking about backing up 62 feet, 24 miles an hour in a blizzard, striking John O'Keefe, throws him 12 feet over a snowbank. That's what I was talking about. That was the information that I was going to, talk about that literally blew my mind when I found out. And I saw that video of the conditions that night and I went, holy shit. That's highly questionable. It's highly questionable what the state is saying now. I would like to see an experiment in a blizzard conditions with at least 2 inches, 3 inches, 4 inches snow on the ground in that type of SUV, backing up on a curved road in the night with a few drinks in you. I don't know. It don't make sense to me. It doesn't make sense. Something doesn't fit.
Up behind me. She then observed the black SUV move from the initial place the vehicle stopped on the street near the driveway and then proceeds to the left side of the property. At 12:45 a.m., she texted the victim hello again and then observed the black SUV drive away. She stated that they discovered the victim in the area where she last observed the SUV on the left side of the property as facing from the street. And at approximately 4:53 a.m., she received a phone call from the defendant looking for the victim. She indicated that the defendant was distraught and drove to her house. The defendant indicated to Ms. McCabe that she last remembered seeing.
Oh, Mary, by the way, in my email with Turtle Boy today, I did raise that question with him, the information that you sent me about the kitchen. He said that it is an open floor plan, and he knows about that, and they've talked about it before. So that was a good point out that you had. But he did get back to me about that. That's kind of what it sparked our initial conversation. So thank you for that. And that was him and I kind of talking this afternoon back and forth about coming on the show. And he said, absolutely. We're just trying to line up a date and time. So we're going to try to make it happen here in the next week and a half. Can't wait. I think it's going to be a really great show.
The victim at the Waterfall Bar.
And I'm definitely going to be preparing and asking a lot of questions.
Ms. McCabe then informed the defendant that she observed the victim and her leave the bar together. Ms. McCabe then drove the defendant's vehicle from her house back to the victim's because the defendant was too hysterical to drive and had the other friend, Ms. Carrie Roberts, follow him. While driving to the victim's house, the defendant stated to Ms. McCabe, "Could I have hit him? Did I hit him?" Ms. McCabe stated that the defendant told her about a cracked taillight on her vehicle. Once they arrived at the victim's home, the defendant had Ms. McCabe looked at that same cracked taillight. Ms. McCabe described the passenger side right rear taillight as cracked. They then both entered Ms. Roberts' vehicle to look for the victim, with the defendant seated in the back.
Yeah, Mary, I'll talk to him about that when I get him on the show. Maybe we can take a look at that. But yeah, it's weird. It is odd. But we'll talk about that a little bit more. I'll look a little bit more into that, Mary.
As Ms.
That doesn't make sense either, that witness statement.
Drove and Ms. McCabe was seated in the front passenger seat. Ms. McCabe stated that they turned on a Fairview Road from Chapman Street. At the time, it was snowing heavily, creating poor visibility. Ms. McCabe stated that just prior to the residence on Fairview Road, there was a cluster of trees, and immediately the defendant stated that she saw the victim. Ms. McCabe and Ms. Roberts were not able to see the victim and were initially confused by the defendant's statement. Ms. McCabe stated that Ms. Roberts began wiping snow off of the victim as the defendant laid on top of him for warmth and then began CPR. The troopers then proceeded to the Good Samaritan Hospital to view the victim. They observed approximately 6 bloodied lacerations varying in length on his right arm, the cuts extending from his forearm to his bicep. Both of the victim's eyes were swollen shut and black and blue. They observed a cut to the right eyelid area of the victim, observed his clothing to be blue jeans, an orange t-shirt, a long sleeve shirt, and boxer shorts that were saturated with blood and vomit. They observed one black Nike sneaker with a white Nike logo on the sides belonging to the victim. On the 31st, the troopers attended the autopsy of Mr. O'Keefe at the Office of the Chief Medical Examiner. The doctor performed the autopsy. Dr. Scorty below advised of several abrasions to the right forearm, 2 swollen black eyes, a small cut above the right eye, a cut to the left side of his nose, approximately 2-inch laceration to the back of his head, multiple skull fractures that resulted in bleeding, and further advised that the victim's pancreas was a dark red color, indicating that hypothermia was a contributing factor to his death. On January 29th, the troopers conducted several other interviews, including Ms. Roberts. During the course of Ms. Roberts' interview, she indicated that she was initially contacted by the defendant, Ms. Reed, at 5 a.m., that she answered the phone to hear the defendant state, "John's dead. Kerry, I wonder if he's dead. It's snowing. He got hit by a plow." The troopers also on the 29th proceeded to the defendant's parents' home in Dighton, Massachusetts, where they located the involved vehicle, which is a 2021 black Lexus SUV. That vehicle was ultimately seized and taken back to the Canton Police Department, where it was processed by various factions of the state police. Their observations of that black SUV indicated a crack in the right rear taillight. They did speak with the defendant. She indicated that she had met with the victim at the C.F. McCarthy's bar in Canton at approximately 9 p.m. on the 29th, that he was there with several friends prior to arrival. She stated the victim was consuming beer and she was drinking vodka sodas. She described the glassware.
I don't work for that fucking company anymore. And right now until, let's see, right now until the 2nd, I have a job lined up, but I'm actually actively not employed at the moment. So I am a full-time YouTuber right now until the 2nd. So X away.
She was drinking out of as a vase style. She stated she and the victim left C.F. McCarthy's and went to the waterfall.
Thanks, Todd. Appreciate you.
She indicated to the troopers that she did not leave C.F. McCarthy's or enter the waterfall bar with a glass or drink. She stated that she and the victim were at the waterfall for approximately 1 hour. During that time, there were no altercations and no injuries, no cuts or abrasions that occurred with the victim. She indicated that they left the waterfall and were invited to the house on Fairview Road. She stated that she dropped the victim at the house on Fairview and went home since she was having stomach issues at the previous bar. She stated that she dropped the victim off. She made a 3-point turn in the street.
I will. I'll be
did not see the
working
victim
diligently on my channel.
She indicated that she first observed the broken taillight in the morning and did not know how she broke it the previous evening. She indicated that she discovered the victim in the morning. She observed him lying face up, snow on his legs, eyes swollen, and blood coming from his nose and mouth, and that she provided mouth-to-mouth upon her arrival. Further indicated that
JD Husk, super sticker, super duper 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 sticker. Thank you so much for the super duper 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 sticker. If you all want to support the channel, you can down there. There's a couple means to do that. You can join by hitting the join button down below. That'll give a monthly memberships. All my monthly memberships, I'm telling you, are the lowest ones out there. They start at $1.99. $1.99, which is less than a Starbucks cup of coffee. You can send a super sticker. You can send a super chat. Whatever you want to do. I have Cash App options as well. It's fine with me. That's my spiel for the end of the night. And if you notice, I am one of the most giving true crime channels out there. We do prize giveaways. I constantly drop free memberships for all my members only content. I'm telling you, you don't see that with any other creators. They don't do it. They don't do it, but we do it here on the LTL podcast. I give back to the community. And if you get a free membership, you can always rejoin at the end of the 30 days. It will be a $4.99 membership that's handed out. You can always rejoin at the end of your 30 days, and you can just join back for $1.99. It helps support this channel. It helps me pay StreamYard so I can keep doing this and keep up on all my computer maintenance and props and stuff like that, travel, gas. That's what it all goes back to that. I don't make any money off this channel. He goes, you make so much money off this channel. Literally, the money that I make off my channel, I got to pay taxes on it. YouTube takes 30%, and then anything else just gets cycled back in the channel. That's it. That's it. If something breaks, I got to buy it. So I do appreciate it. Let's do this real quick. I haven't done one of these in a while.
Had your kids, had your wife.
And thank you for the super sticker. Homie. All right, let's keep playing through the hearing.
That throughout the night she'd been calling and texting the victim numerous times with no response. Officers also interviewed several first responders, including a firefighter paramedic from the town of Canton, indicated that she arrived on scene, observed the victim's condition, went to speak to the defendant.
Gotta win the
tote. Any sort of prior medical issues or causality of the injuries that she observed to his face. To which the defendant then made several statements to her, indicating, I hit him, I hit him, I hit him, I hit him. As I mentioned, the black Lexus SUV was seized. There were fragments of broken glass that were observed on the rear bump of the vehicle. The rear
Carrie, thank you so much.
Taillight was shattered, pieces missing.
For the 25, thank you so much. I appreciate it.
On the right side of the rear tailgate, a deep scratch and minor dent was observed. On the right side of the rear bumper, above a small red light, 2 scratches were observed in one area.
When we get to a hundo. likes tonight on
Troopers
the
from the
drop.
Collision Analysis and
5
Reconstruction
free
Section of the State
memberships.
Police performed several tests on the vehicle, including a rapid acceleration, forward and reverse, noting that there was no deficiencies with the braking system. They also implemented the use of a training figure resembling a human approximately 6 feet in height that was placed behind this Lexus. It was operated by members of the CARS unit and documented with video. The vehicle was placed in reverse and started to travel towards said training figure. The rear view camera on the vehicle was operating properly, providing a 180-degree visual. And as the Lexus traveled closer to the figure, both auditory and visual cues began to sound off within the vehicle, indicating an obstruction to the rear. In addition, on the 29th, the Massachusetts Special Emergency Response Team, or CERT, was activated to assist in searching for potential evidence outside of the residence. Standing on the street, looking to the left of the property, there was a fire hydrant located there. In that area, they located a black Nike sneaker with a white Nike logo along the side, matching that found on the victim's body. In the area of the street where the victim was recovered. In addition, in that same area, they located 2 red plastic pieces of a taillight consistent with the missing pieces from Miss Reed's black Lexus SUV, as well as 1 piece of clear plastic piece of a taillight located in the same area, also consistent with the broken taillight on the Lexus SUV. Your Honor, with the nature and circumstances of those facts, as well as the potential penalty the defendant faces on these charges, the Commonwealth is requesting that the court set a $50,000 cash bail with the conditions as outlined previously.
Thank you, Mr. Lally.
Thank you.
Mr. Yannetti, and if you would, go right to the mic.
Thank you, Your Honor.
Gonna hear from the defense now.
Good morning again, Your Honor. David
Yannetti.
Yannetti for Karen Reed. Judge, my client is 41 years old with no criminal record. My client grew up in Canton, Massachusetts. She's a graduate of Coyle Cassidy High School in 1998. And when it came time to go to college, she stayed in Massachusetts and went to Bentley College. She graduated with a Bachelor of Science in Finance in 2003. And since then has worked in the financial sector. And in fact, she's been at a very large, well-known financial company since 2007, where she's currently an equity analyst. In addition, she's an adjunct professor at a Massachusetts university as well, and she's been there since 2008. In addition, Judge, my client suffers from a host of medical issues. From the time that she was 25, she's had multiple serious illnesses diagnosed, beginning in 2005 with colitis, which ultimately led to her colon being completely removed in 2009. She's been in pain for a number of years, and eventually also was diagnosed with MS as well in 2013. Continued to have digestion issues and bowel issues, and this past summer, my client unfortunately was diagnosed with having a brain tumor as a result of migraines that she had never had before. There is still no answer regarding whether that brain tumor is cancerous or not. And I bring this up not for the purpose of evoking any sympathy, but to focus on what the court's inquiry is here today. The inquiry is, what is the likelihood that my client will appear in court for her trial? Does bail need to be set to assure her appearance at trial? And if so, how much bail should be set? Her roots are here. She was born here, she went to school here, she went to college here, and her doctors are here. And in addition, her family is here. Her parents are present in the courtroom, her brother and her sister-in-law are present in the courtroom. And Your Honor, just so the court's aware, I'd like to have a letter that I sent to the Norfolk County District Attorney's Office this weekend. It was faxed on Saturday, where I promised that my client would appear if they just called me. All they had to do was notify me, and I wrote right in the letter that she would report to any police barracks or police station or courthouse to which they directed me. They ignored that and instead got an arrest warrant for my client. However, She knew. She had hired an attorney since January 30th, this Saturday, because the police had come and they had taken her phone and they had taken her car. She knew that they were considering her a suspect, rightly or wrongly. And what did she do? They arrested her at the very address that I included in my letter to the Commonwealth, which the Commonwealth ignored. This is relevant, I would assert, Judge, regarding whether she is a flight risk. I think that it doesn't really pass the straight face test. She is not going anywhere. She didn't go anywhere. I frankly don't think they've overcome the presumption of personal recognizance in this case. With regard to the facts of the case, Judge, I've read the affidavit that the prosecution has now read. Manslaughter is a tremendous reach in this case. I don't see any criminal intent that would justify manslaughter in that affidavit. And there's a reason for that, because there was no criminal intent. This was not some random stranger. This was my client's boyfriend, somebody with whom she was in love, somebody with whom she essentially lived with. And by the way, the police have her phone. At 4:30 in the morning, my client is placing multiple calls to the victim in this case, to her boyfriend, wondering where he is, why he hasn't come home, and getting annoyed with him because his niece, of whom he was a guardian, had to go to bed without saying goodnight to him. She had no idea that he was deceased or that anything had happened. At 5:30 in the morning, she's placing probably about 10 calls to him for the same reason, before she now knows something's has to be wrong, because he never stayed out at night without her. If they were ever out at night, they were always together. He had never not come home. And that's when she calls her girlfriend and goes back to the scene and sees this horrific scene. So, Your Honor, this is a defensible case. There is no reason for her to run. She's done the opposite. She hired an attorney almost right away. And by the way, there will be
Lee, I apologize with the $4.99 super sticker. Sometimes I have 3 screens in front of me. So I'm literally watching Twitter. I'm watching the video. I'm watching myself. I have a screen here with notes on it. So it's hard sometimes. And I've always said that sometimes I will miss things in the chat. If I'm not just staring at the chat at that time, it'll go by too quick and I don't see it. So I do apologize. It's not intentional. And I do appreciate the super sticker. Thank you so much. It's a lot. When you run a live show, people don't understand. And John's in the chat. He knows. There's multiple things you're doing when a live show is going. You're producing, you're chatting with people, you're in the chat, you're looking up and seeing if there's any problem. Like I have the stream playing up here as well in the background to see if there's any issues going on. Is there anything that I missed? So I do appreciate it, and I apologize. And that's why I say sometimes when I'm doing presentations, when I have the presentation board up, I'm not going to see chats during that because it's impossible. It's filled up on the screen, and it's impossible to look at chats. I'm sorry. So I do apologize. I try to do the best that I can. I'm multitasking like 20 different things right now. So I try to keep the show going so I don't have to stop it. Because, after a certain amount of time, people tend to check out after about 2 hours. So I appreciate you. Thank you so much. I appreciate that super sticker. Thank you. All right, let's keep playing through here.
Substantial issues regarding a motion to suppress statements here. As I put in the letter, and I'd like to, again, have this marked as an exhibit for the bail hearing. As I put in the letter, the police multiple times violated.
Not ignoring. Thank you.
Mr. Lally, any objection to the letter committee?
No objection.
Yeah,
Right,
I've been
thank you.
contacting Anthony for a while.
Thank you very much. The police violated her right to counsel multiple times, Your Honor, and we'll be able to show that at a motion to suppress hearing. Their case essentially comes down to statements because there's no eyewitnesses. There doesn't appear as though there's any video evidence. There's nothing to indicate what actually happened on the day in question. And I think the police acting out of desperation, realizing that they didn't really have much of a case, needed some type of confession
Leave
from
it
her.
to 1999.
She
Thank you
did
so
not give
much.
it to them,
Appreciate
and yet they
you.
questioned her despite the fact that she asked for a lawyer. So the bottom line, Judge, is
Had
the
your
defense of
kids,
the case,
had
she's
your
not a
wife.
flight risk, and recognizing the seriousness of the charges, I won't ask for personal recognizance, but I would assert to the court, this case does not justify more than a $5,000 cash bail.
Thank you. My guess is you have no objection to
nothing on the wrist.
proposed conditions.
Well, the only condition that I would ask to be heard on, Your Honor, is this condition that she not drive. The police and the district attorney's office and the registry of motor vehicles have options to address that issue if they believe that she's an unsafe driver. And I would ask the court not to get involved with that issue.
Thank you. All right, with regard to the conditions, she is ordered not to drive unless licensed or permitted by the Massachusetts Registry of Motor Vehicles. I appreciate your argument, Mr. Yannetti, but due to the nature and the circumstances of the offenses charged, specifically 1 and 3, and the potential penalty, I know what your letter says, you're the lawyer, but she has plenty of reason to flee. Given the potential penalty, I'm opposing the $50,000 cash. Yes, on the motion, I have Mr. Lally, a motion for preservation of evidence. Have you had a chance to review it?
I have, yes, sir.
Do you have any objection to it?
I do not, Your Honor.
All right, thank you. I'll allow that.
Can I have a date, please?
And just to be clear for the record, with regard to that motion being allowed, Judge, I would ask that it be effective with the court's signature with regard to previous reports that have been filed and anything that's been gathered, and certainly going forward. There should be no destruction of notes going forward in this investigation.
Well, it speaks for itself.
Yes.
It's a preservation of evidence. I just signed it. It's 10:22 a.m. on February 2nd. That's when it's effective.
Thank you very much, Ron. In terms of a next date, could I have March 1st, Judge?
Sure. Mr. Lally, that work for you? If not, we'll go to another day.
If possible, yeah. If possible, the 3rd or the 4th, if that's.
Well, I mean, she is entitled to be brought back within 30 days.
Sure.
I mean,
But Mr.
Lally,
Lally, if I may, Mr. Lally, you can have a 9 o'clock, 11 o'clock, or 2 o'clock call.
then thank you. 11 o'clock on the 1st is fine.
All right. That work, Mr.
that
Yannetti?
works.
Thank you.
Mr. Docket 22 CR 66, court is setting bail in the amount of $50,000 cash to ensure your presence back here March 1st for a probable cause hearing. You have a right to petition the Superior Court for a review of that bail. Conditions of this case are that you stay away and have no contact with the victim's family, stay away from the victim's residence, and do not drive a motor vehicle unless permitted to by the Registry of Motor Vehicles. You'll need to sign those conditions before you're transported today.
Thank you, Ron.
Thank you.
Thank you, Ron. Thank you, Don.
Okay.
All right.
All right, let's go to the other hearing. This is May 3rd, and then we're going to play a July hearing. So May 3rd. So I got a question. Maybe someone will know the rules about bail. So 50K would be 5,000, right? It's 10%. Am I right on that? Or does she have to pay the 50,000? I think it's 10%, right? Maybe John knows. All right, let's play that hearing. May 3rd. May 3rd. This is when she's second time in court.
Good afternoon, Your Honor. Attorney David Yannetti and Attorney Ian Tenchi from the Yannetti Law Firm. Good afternoon.
Good afternoon, Your Honor. Alan Jackson from Worksman Jackson and Quinn, along with Elizabeth Little from Worksman Jackson and Quinn on behalf of Kieran Reed.
Good afternoon, Mr. Jackson. Good afternoon, Ms. Little. Good afternoon, Ms.
I just don't, I don't understand, because I'm sitting here and I look at the chat and people come in and we get an elevated level of people and then they just back out. This case is so important. It is so important. And I'm going to continue to talk about this case and get so many eyes on it. I don't care if there's 3 people here. I don't care if there's 1 person here. I don't care if there's 3,000 people in the chat. I am going to continue to talk about this on the channel. So get ready. There's going to be a lot of material here. Just because it doesn't say fucking Idaho in the title, like all these stupid creators out there, and I can call out maybe a few of them that continue to overload YouTube with Idaho content. You're not going to solve the fucking case. Quit implementing conspiracy theories in that damn case. You're just beating a dead horse at this point. You're not going to solve it. There's no mysterious man that came in. The college students up the street didn't do it. Steve Gonzalez didn't cover up evidence. Like, stop with the bullshit. You know the channels that are these fake channels that have 60, 50,000 subscribers on them. You know, the fake subscribers, when they go live, they constantly have 1,500, 2,000 people in their fucking chat every night. It's impossible. It doesn't happen. It doesn't happen. It cannot happen. It doesn't happen. This is a case that needs a lot of eyes on it right now. I'm telling you. I just saw someone today. I can't think of her name. Elisa 10 to life. She just did a video about this today. She got 1 million subscribers. Oh, it's heating up. It's crazy. It's such a big case. Within an hour, 83,000 views. 83,000 views. And here I am talking about this night after night after night and can barely get a couple hundred views on my video. Tell me something is not wrong in this algorithm. Tell me something's not wrong in this algorithm. Tell me. I'm a Massachusetts native talking about this case 20 minutes from my house. And I can't get a couple hundred views. But someone out in LA with a fancy fucking studio and a name and 1 million subscribers drops a video, and in an hour, 83,000 views on that video. And that's what I laugh about it. YouTube, they sit here and say, oh, subscribers don't mean anything. Subscribers mean everything. If your content is not being played, your content's not being pushed out there, and your viewers are not coming to the content, this algorithm's not going to push it. But I'm going to continue to drill this down and keep talking about it. I will not have YouTube suppress me on this. I won't have it happen. I will not have it happen. All right, let's keep playing the court hearing.
We're here for the Rule 17 motions. Who's going to argue those?
So, Your Honor, there are 2 motions before the court that we'd like
One
to be heard on.
One is talk about this. One particular creator that's not even from this country, that constantly bags on our fucking legal system, always loves to interject major conspiracy theories and cover-ups in the Idaho case. You know who it is. You know who it is. Wears a hat kind of similar to mine tonight. Bullshit content. It's all bullshit content. Stop looking at these people. They're morons.
A motion to renew our motions to compel, which we'd like to be heard.
Cracks on our legal system all the time. You know,
and I will be arguing
here.
that motion. With regard to the Rule 17 motion for the animal control.
You have no rule of law in this country. You have no rule of law. You have nothing to do with our legal system. Nothing to do with our legal system, but you sure crack on it a lot.
My colleague, Mr. Jackson, would be arguing that second, if the court pleases.
Okay. All right, I'll hear you.
Thank you, Your Honor. May it please the court. We are seeking immediate access to John
wind up
O'Keefe's
tomorrow
clothing,
night.
all evidence seized from my client's vehicle, to tissue and other samples from John O'Keefe's autopsy, and to the original Canton Library video, which we still do not have. We are asking this court specifically to set a hard deadline for access to this mandatory discovery and evidence. Your Honor, at the outset, it is important for me to emphasize why a deadline needs to be
I'm working on
set.
it, Lee.
It's important to emphasize.
I had a conversation with Turtle Boy today, and I'm sorry. I apologize. I'm talking over this hearing. I'm just trying to respond to the chat. Yeah, I was talking to Turtle Boy today. We're just trying to line up a date and time, hopefully for next week. He said that he will come on the show. I can show you the email if I need to do that. But he said he's going to come on the show. We were going back and forth. He probably got tied up. He just hasn't answered me yet. And we'll try to figure out a schedule. My schedule next week is a little wanky. So, if it doesn't happen next week, maybe the week after that. But I'm going to get him on at some point here. some point here. Thomas Rhodes says, I'm 100% sick of the Idaho case. People need to stop talking about that case until trial or new evidence comes out. This case has major corruption from the Canton police and to the ATF. So that's how Thomas feels in this case. Yeah, you know, it's literally, I go to these creators pages and it's constantly like Idaho. They don't give a shit about any true crime. They're fake true crime people. If they really cared, they would be talking about other cases that need attention. But these people, because all they want is clicks and views, because most of the people that have joined their channel have become because of Idaho, and they have to keep feeding that beast. So they probably get up every morning and they sweat and they go, oh no, what kind of video am I going to make today? Oh, let's talk about the guy that was caught in the video that was maybe outside the house when the news channel scrolled by, and the guy in the yellow coat. Let's talk about him today. Maybe he's the one that did it. Maybe he's the one that went inside the house and cleaned up all the evidence. He's talking about today about, what was he saying today? That people inside the house cleaned up all the evidence, and that's why there's so confusion about Dylan and Bethany. I'm like, dude, how many times are you gonna keep beating this dead horse? And these fucking people come back to it. They come back to it. And they're like, oh my God, you're investigating and your theories are so dead on, blah, 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 blah. Stop watching these people. They don't give a shit. They don't give a shit. They don't give a shit. He doesn't care. He's not a true crimer. He's not a person that will dig in and peel back the onion layers in cases. All they care about is just getting on a sexy subject. I mean, what's this guy's channel going to do when Idaho goes away? Think about that. What are you going to do? What are you going to do? People aren't going to watch you. People aren't going to come back to you.
That's why time is of the essence for our access to this evidence. It's been 15 months since my client was arrested and falsely charged with killing John O'Keefe. Prior to 15 months ago, my client was employed in 2 prestigious positions. Prior to 15 months ago, she had a robust health insurance plan that covered her numerous serious medical conditions. But 15 months ago, she lost everything. 15 months ago, these false allegations began to destroy her life. And for the last 15 months, she has been fighting for her life. 15 months after her arrest.
Oh, by the way, if anybody wants to know, that's Turtle Boy right here, sitting in the front, right here.
She has no income. She does not come from a wealthy family. Her father was a respected and now retired educator. Her family is very squarely middle class. But given that Karen Reed is now fighting for her life, whatever money that they've saved is all going to her defense in this case. She's hired private counsel from 2 coasts. She's hired multiple experts at considerable costs. And when I say considerable, I mean tens and tens of thousands of dollars. And the meter is running with each passing court date. She can't afford to scrimp on her defense because her life is at stake. In the 11 months that this case has been pending in this court, we have continually asked for access to the same basic mandatory discovery evidence. We've been prohibited from inspecting that evidence. In February of 2022, the police seized John O'Keefe's clothing. It's now May of 2023. We haven't seen it. We haven't inspected it. We haven't been able to test it. In February of 22, the police seized pieces of taillight from my client's vehicle, pieces that they claim to have found at the residence where John O'Keefe died, despite the fact that multiple searches initially turned up nothing. Pieces of the taillight were only found after Trooper Michael Proctor, conflicted Michael Proctor, had seized my client's vehicle and had it in his possession for well over an hour. That evidence needs to be put to the test, and it needs to be put to the test now. We have been prohibited from testing it, from inspecting it, from even seeing it. There were tissues and other samples from the autopsy of John O'Keefe to which we've been denied access. We believe that when those samples are tested, the results will be exculpatory, likely case ending.
That's Detective John's favorite word, exculpatory. He always says exculpatory evidence.
But 15 months after she was arrested and 11 months after she was arraigned in this court, That evidence remains hidden from the defense. The police have maintained exclusive control over the event data recorder and the Lexus infotainment system from my client's vehicle. We have seen neither, and this is simply unacceptable. Prohibiting the defense from inspecting this evidence is infringing on my client's constitutional right to a speedy trial, and it's infringing on her right to due process. It's almost 3 months ago that we last appeared before you, Your Honor. We requested access to these items, and yet again, have the response from the Commonwealth was that they would be tested soon. The prosecutor had represented within 30 to 60 days. That's on record. It's now close to 90 days. We've made zero progress. This court did order that the Commonwealth request expedited testing, but that order has yielded nothing. I asked the court to set deadlines then, which the court was not inclined to do. 3 months later, it is crystal clear that deadlines need to be set. Without
Oh, sorry, my mic was muted. I said we have 72 people in the chat right now. If you haven't smashed that like button already, please smash the like button. It's very, very important to get this stream out there. We need 100 likes to beat back the YouTube algorithm tonight. We will not be suppressed in our true crime ventures, our journeys. This is a very, very important case. I'm going to continue to do lots of videos on this case. And you will see when the mainstream media and all these other YouTube channels start jumping on this case, because it's going to be hot and it's going to be the next thing. I'm telling you, these people don't care. They don't care. I'm a Massachusetts native. This crime happened literally 25 minutes from my house. I will be out there tomorrow, boots on the ground. I promise you that. I will be out in the neighborhood of 34 Fairview live to give you boots on the ground coverage, to look at in and around that home, in and around that neighborhood, and I'll let you determine what happened. But I'm telling you, you watch. They will all jump on this case, and I will be here doing it before they all do it. So smash that like button. Let's beat back this algorithm. Let's not let YouTube defeat us. We need eyes on this case. We need the evidence. We need the proper evidence to come out. All right, let's keep playing this.
a deadline, we have no assurances that this case will not drag on who knows how long into the future. With each passing day, my client, who not only is presumed to be innocent, but is factually innocent, remains jobless, with inadequate health insurance, and with each passing day, her savings and her family's savings continue to be depleted.
Out there.
There is no time to wait.
LTL deserves to be out there on the map. We deserve it. We work hard here. You all come into this chat on a nightly basis. And listen, I'm not the trendsetter here. Turtle Boy really is the trendsetter on this. He's been in this case every day. He's got 160 entries in his blog about this case. He's been doing it for 6 months. Yes, I finally have awoken. I've known about this case for a while. I talk about it at my friend's house when I go over there, because they live in Mansfield. Mansfield's from here is 10 minutes. Canton's the next couple towns over. But I finally awoke because I started reading about it, researching, and I'm now captivated. I'm telling you, this you gotta get on this case. You need to watch these streams. It's very, very important, super important. And I'm gonna beat this thing to death until it goes to trial and we figure out what happens. And I'm gonna make sure that I'm there in some of those court proceedings. It's gonna happen right in my community, so I'm gonna be there for the court hearings. And when this goes to trial, if I can get in to sit down, luckily Boston courtrooms are large, so I may be able to get in. And Karen Reed is set for a March trial date, so we will be there. We will be there. All right, let's keep playing through. I apologize. I've stopped the hearing. I hope we can get through both of them, but I don't know if we're going to tonight. But I will get through these in the next couple of nights. All right, let's keep playing through here. I'm going to back this up a little bit. I apologize. I like to talk during my live shows. I interact with the audience. I know I get a lot of shit about that. This is a live show. It's a live show. We interact here. We talk. We talk these things through. I love it. I love doing this. I absolutely love it.
Did order that the Commonwealth request expedited testing,
I love it.
but that order has yielded nothing. I asked the court to set deadlines then, which the court was not inclined to do. 3 months later, it is crystal clear that deadlines need to be set. Without a deadline, we have no assurances that this case will not drag on who knows how long into the future. With each passing day, my client, who not only is presumed to be innocent, but is factually innocent, remains jobless, with inadequate health insurance, and with each passing day, her savings and her family's savings continue to be depleted. There is no time to wait. There is no time to waste. It is time for excuses to end. As we noted in our motion, the prosecution and the crime lab move very quickly when they want to. In other cases pending before this very court, the very same investigators secured DNA testing within 2 weeks of opening their investigation before anybody was charged. Contrast that with our case, where here we are 15 months later, no such testing has even started. Regarding the Canton Library video, this court should know we still do not have relevant time periods. From the Commonwealth's evidence, we know that my client drove by the Canton Library at 12:16 a.m. on January 29th because that was recorded. There is video of her driving by at that time, heading to 34 Fairview, which is where John O'Keefe died, with her taillight intact. We know that my client arrived back at John O'Keefe's residence at 1 Meadows Ave in Canton at 12:41 a.m. because the Commonwealth produced a voicemail that she left for John, where you can hear the garage door closing, the car door closing, the house door closing while she walked in her high heels on the garage floor. 1 Meadows is about a mile from the Canton Library. We know the video equipment was working because they have that footage from 12:16 a.m. But in the video that the prosecution turned over to us, there is a gap in that video from 12:37 a.m. to 12:39 a.m., which would have been the precise time my client would have been driving back past the library. We know that that footage would show that my client's taillight was still intact at that point because she never struck John O'Keefe with her vehicle. Yet the prosecution has produced a video from the library with that crucial time period missing. This evidence is strictly in their possession. We've been told that the Canton police provided the evidence to them via a share file. The Canton Library provided this evidence to them via a share file link with a guest ID and a guest password. We need that link, that user ID, and that password. We cannot rely on Trooper Michael Proctor, conflicted Michael Proctor.
Now, Michael Proctor has been a huge question of in this case. A couple of facts about him. He's very, very close to the Albertson, Brian Alberts. And Brian Alberts, at the time of the incident, lived and owned the house at 34 Fairview. And this state trooper became the lead investigator in this incident, in this crime. And they're very, very close. Their families hang out together. They go to, Turtle Boy was reporting, they go to Sears or one of those places that, I don't even know if Sears is around anymore, that do family portraits, and they take family portraits together. So it's just very interesting. Very, very interesting.
To sanitize exculpatory evidence before sending it to us. We need the original footage. If the Commonwealth answers that original footage no longer exists, then we'll need an evidentiary hearing to put the relevant parties under oath to find out what happened to it. The bottom line here, Your Honor, is that we've spent 15 months trying to uncover the truth. We are not afraid of whatever evidence is unearthed from whatever source, because for 15 months, every stitch of evidence has been consistent with my client's innocence. However long this case lasts, and I sure hope the prosecution comes to their senses and realizes they have no case because they've charged the wrong person. But however long this case lasts, the remaining evidence will drive a stake through the heart of this prosecution. In the meantime, my client suffers. In the meantime, her life is on hold while she spends every waking moment defending herself emotionally, intellectually, and financially. We cannot abide by excuses any longer. We need this court's help. We need you, Your Honor, respectfully, to hold the prosecution's feet to the fire. We need this court to order the Commonwealth to stop trampling on my client's rights to a speedy trial and her right to due process. We need this court to set deadlines for the production of this evidence. Thank you.
Okay, thank you. Mr. Lally?
Yes, Your Honor. So in response to counsel's motion, just in response to the statement that every piece of evidence that's been provided thus far is inconsistent with the defendant's guilt and consistent with her innocence, I would have a large issue with that. But as it pertains to these particular pieces of evidence, counsel's right in that motions were filed. Counsel's right in that motions were allowed when, as related to inspection of said materials, and the Commonwealth has no issue with inspection of materials once they're back from the lab. Now, the last time we were before this court, back in February, the court had asked myself to reach out to the lab and see if there was anything that could be done to expedite the analysis. I did that, spoke with and filed the necessary paperwork with the lab to expedite as much of the analysis as could be done at that particular time. So at that time, what I was provided with was a deadline of no later than May 5th. Those items, at least as far as the trace analysis.
I don't know what that audio problem is. It sounds like it's something in the courtroom, so I do apologize if you're wearing headphones. I have no control over that, so I know it's a little annoying. It's even annoying me right now. It's hurting my ears, so sorry about that.
And the criminalistics was concerned would be completed, and I should expect something close to that date. I confirmed with the lab as of yesterday that timeline is still a viable one. The case is currently in technical review, so once that's completed, then we should have reports that I'm able to provide to counsel. As it pertains to the inspection and the return of the items from the lab to the Commonwealth's, well, at least the District Attorney's Office for the State Police's custody, one of the issues that we've had with that is that in order to facilitate some of the necessary DNA testing, some of that testing would be exhaustive. And in particular, there is a hair sample that was recovered from the rear right quarter panel of the defendant's vehicle. It was taken to the lab, and I was informed by the lab that any testing of that for DNA, for comparative purposes to Mr. O'Keefe, would be exhaustive. So on March 10th, I sent counsel a exhaustive testing form that needed to be filled out, whether or not they want an expert present for that testing or don't want an expert present for testing is really immaterial, but I need some sort of authorization from counsel before the sample is subsumed during the course of testing with the lab. I haven't heard.
It's crazy. Like, you watch, like, I'm just going to, in comparison, you see like the Idaho case, right? Their courtroom is so small. Boston courtrooms are huge. You can pack in a bunch of people, and, they're almost as big as churches out here. They're huge. And, a lot of old school courtrooms out here. So, you really get to see the piece of history, how courtrooms really were way back in the day. So really interesting stuff. All right, let's keep playing through here.
Heard anything back from counsel. I spoke to counsel numerous times. I sent emails. I heard no response as far as that. So as far as the DNA testing is concerned, the delay on that is because I don't have anything back from counsel as far as whether or not they want an expert present, who that expert is, how to contact them, and how to facilitate the beginning steps of that particular testing. So that is why at least in no small part, why some of the items are still contained at the lab is because the testing is still yet to be completed. But I do hope to have the trace and the criminalistics, and I expect that by next week at the latest. And again, whatever deadlines that the court sees fit to or deems fit to put on certain things, as far as that's concerned, is certainly within the court's prerogative. I don't think that we need deadlines. I don't think that we need an evidentiary hearing as it relates to it, but that's where it stands. As far as the video is concerned, the video was provided by the IT director for the town of Canton. There was a share file that was shared with the troopers. The troopers, upon receiving that, it was Trooper Dunn who received that video, not Trooper Proctor. If I could just speak briefly as it pertains to Trooper Proctor, there is no conflict. Trooper Proctor is not conflicted in this case. I indicated that specifically in some of the oppositions that were filed to Rule 17. So there's been some photograph taken from a social media site, which is purported to be Trooper Proctor with one of the McCabe's children who are a witness in the case. The child that's depicted in that particular photograph is not one of the McCabe's children. The McCabe's have 4 daughters. That's not one of them. It's a relative of Trooper Proctor. It has nothing to do with the McCabe's and nothing to do with this case. Whatever conflict counsel believes Trooper Proctor has just doesn't exist. Now, as far as the video was provided to Trooper Matthew Dunn of the CPAC unit with the District Attorney's Office, that was then shared with Ms. Crawford. It was a person in our office who specifically who deals with forensic and surveillance video and type evidence. It was then archived on our system. Recently, we reached out and spoke to the IT director with the town of Canton again. That share link I tried to send to council, email essentially wouldn't go through. We tried to open it, essentially it won't open. So the link expired within 30 days within 60 days, if not 30 days of it being shared with our office, but the exact information that was provided by the town of Canton was archived by Ms. Crawford, was then provided to council at her arraignment in Superior Court, as well as I was able to download it onto a Citrix file, which I then shared with council earlier this week. So what we have as a video, what exists as a video, what we were given as a video for those relevant time frames was placed onto the archive within our system, was then placed onto a disk, and what's on the disk and what's been provided to council is what we received.
Okay. All right, your next motion?
That would be Mr. Jackson.
Okay.
Yeah, we're going to play all those hearings probably the next 3 nights here. I'm going to get through this one and probably wrap it up tonight because we're at about an hour and a half. I spent a lot of time kind of stopping and yapping my trap tonight, but I think these are important to go through and review to show the people so they can understand here what this case is about. It's good review, and you're seeing both sides of the argument here. So let's keep playing through here. We still need 8 more likes to get to 100. And then once we get to 100, I'll drop out some free memberships.
Good afternoon, Your Honor. May it please the court. We are, as indicated in our papers, we are seeking summonses, and this is dealing with the animal control issue. That Rule 17 motion, we're seeking summonses directed at 2 entities, the Canton Animal Control and the Canton Town Clerk. Both.
Now this is about the dog.
We believe they both have records. We know they both have records. These are records that we need, the defense needs to shine a light on Karen Reed's innocence. These are records that are essential to our theory of the case. And these are records that we have no other option to get but through a summons. They've indicated to us they have the records, but they need a court order. They need some sort of a summons. Your Honor, in furtherance of this motion, I want to talk for a quick second about a couple of undisputed facts. Undisputed fact number 1, on January 29th, 2022, Officer John O'Keefe was found dead in the yard of Brian Albert at his house at 34 Fairview in Canton.
This is going to be really, you're going to really want to listen to Alan Jackson here. This is going to be really interesting stuff that he's going to put out there. So
that is undisputed fact, where he was found dead and what the circumstances were surrounding that death are why we're here now. Second undisputed fact, when John O'Keefe was found, he had this set of wounds on his right arm. The medical examiner indicated that these wounds were concomitant with his death in terms of the temporal, the time that he died. These were wounds that he suffered at or near the time that he died. And the Commonwealth looks at these wounds and says, there's nothing to see here. Why are we looking at this? This is, you're following a red herring, basically. This is just a road rash. This means nothing. It has no impact on our case one way or the other. This is, according to the Commonwealth, simply a set of injuries that John O'Keefe suffered at the hands of being struck by a moving vehicle. Well, first, I would ask the common sense question, does this look like a road rash? I mean, the court's got years, decades of experience, life experience and legal experience. Of course, this doesn't look like a road rash. It's not a road rash that any of us have ever seen. Or does it look more like claw marks and bite marks from an animal, which is exactly what they are? Second, if it was a road rash, where's the rest of the road rash? John O'Keefe had one set of injuries like this. Deep scratches, deep puncture wounds on his arm, on his right arm only, from mid-biceps to mid-forearm, and no other place.
Just want to show you something really quick. Right here. See that? That's German Shepherd bite and scratch. Just putting it out there for you to look at. Again, we're not just comparing a few things. Just making you think. All right, let's go back to that. JD, I'm going to get to your super chat in a second. I appreciate you.
For instance, mid-biceps and mid-forearm that you might put in front of your face.
JD with
or
the
your body
$9.99.
If a large animal was
Buy a large sandwich or a small combo somewhere cheap. Lunch is on me tomorrow. Thanks, Brian. JD Huss, thank you so much. I appreciate your support. Your support.
Great cash, homie. Hide your kids, hide your wife.
All right, let's keep playing.
was attacking you,
Thank you.
resulting in these wounds. Why are the wounds confined just to his right arm? What about all the other pointy bits of a human body? If someone is rolled under a car or rolled in gravel because of the car, what about the shoulders? What about the knees? What about the ankles? What about the elbows? None of that exists. These are the only wounds. They're confined to his right arm, and they're deep scratch wounds, puncture wounds that are indicative of claw marks and bite marks from a large animal. And third, what about the Commonwealth's own expert? She has to have opined about this, correct? She has to have said during the grand jury, I mean, this was a full-throated investigation surrounding the potential murder of a police officer. What does the Commonwealth's own expert say? First of all, she was never asked by the Commonwealth during the course of the grand jury about the injuries. It took.
Just want to show this as well. Again, just putting this out there to make people think. This right here. Let's see. Hang on. Let me get past this. Let me bring this up. Again, just trying to make people think a little bit. There's a dog attack right there. If you want to compare the injuries. Again, just throwing it out there, making people think, open their minds a little bit. We don't know. All right, let's keep playing through here.
A grand juror actually asking the question of the witness, and she said, no, I cannot say that is a road rash. There's certainly not enough evidence to suggest that these wounds are consistent with a road rash. Well, she had to have at least talked about the fact that it was an animal, right? She had to. The Commonwealth had to have asked that question. She actually said nothing about whether or not that's consistent with an animal, because the Commonwealth very particularly did not ever pose that question. But we did. We hired one of the preeminent medical examiners in the country, a doctor by the name of Sheridan, Frank Sheridan, who wasn't some deputy medical examiner. Dr. Frank Sheridan was the medical examiner for San Bernardino County in California, with more than 12,000 autopsies under his belt, the supervising medical examiner for one of the largest counties in California, and he concluded to a scientific certainty that these wounds are from an animal attack. Period. Full stop. So, what do we know about
Todd, Mamas, Willow,
and the Albers?
Michelle? Welcome.
Which is exactly where
Just Debbie. Hide your kids, hide your wife.
Officer John O'Keefe
Hide your
was found
kids,
dead.
hide your wife.
In February of 2017,
Thank you.
we know that the Alberts had a dog. There's a photograph.
This is important. This is important.
Brian Albert with a dog, Chloe in the foreground. By 2019, the Albert family had registered ownership of that German Shepherd. Moving on to 2022, in January of 2022, specifically January 29th, John O'Keefe suffers these animal puncture wounds, these animal scratches, these animal bite marks that are heretofore and up to this date, today, completely unexplained by the Commonwealth. By May of 2022, Karen Reed's defense team starts asking questions about this animal, about these injuries, about the dog, about what dog existed at the Alberts house. Where is the dog? We started inquiring pretty significantly. That same month, amazingly, the Alberts informed the Canton Animal Control that the dog was remarkably and mysteriously rehomed. The dog was gotten rid of. And to date, the Commonwealth has yet, as my colleague just mentioned, has yet to release the tissue samples to us for DNA testing to determine if there's evidence in these wounds of a canine attack.
Okay. There you go. They did swab. They still haven't gotten the evidence to test. Let's back that up a little bit and listen.
We started inquiring pretty significantly. That same month, amazingly, the Alberts informed the Canton Animal Control that the dog was remarkably and mysteriously rehomed. The dog was gotten rid of. And to date, the Commonwealth has yet, as my colleague just mentioned, has yet to release the tissue samples to us for DNA testing to determine if there's evidence in these wounds of a canine attack, which we believe there will be. During that grand jury testimony, Brian Albert admitted to three things. Number one, he admitted that he owned a large German Shepherd. His words, not mine. A large German Shepherd. Number two, he admitted that the dog was at his home on the night.
Yeah, I just want to make sure that we stop this and let's regroup a little bit for a second, okay? I want to make sure that everybody has a great understanding here as to what my stance here is on LTL. LTL supports and backs law enforcement 100%. 100%. I'm a Second Amendment advocate. I'm a First Amendment advocate as well. Okay. The problem here that I see is that John O'Keefe, a Boston police officer, is dead. And there's only three plausible situations that could have happened. One, Karen Reed got John O'Keefe outside that SUV that night, drove up 62 feet, sped back at 24 miles an hour, hit John O'Keefe. He flew over into the snow. She drove off and went home, and he died. The second scenario is John O'Keefe was dropped off. Karen Reed left and went home. John O'Keefe made it inside the house. There was a fight. Maybe something got out of hand. In that fight, O'Keefe died, and he was brought out in the snow to die. Third scenario, Karen drove up 62 feet, maybe thought she forgot something or wanted to turn around, backed up, didn't realize she hit John, left and went home, right? Those are all three plausible scenarios. I want to try to take out of the equation. Listen, and this is tough for me to talk about. We know that in the system, there is corruption. We know that things like this can happen. We know that cover-ups can happen. Now, I'm not claiming that because I don't have the evidence to say for sure that this is 100% a cover-up. But there's a lot of weird things in this case. And there's a lot of weird things that are making me look in a different direction that may not agree with the PCA, that may not agree that Karen Reed should be arrested for this. And I know that I'm probably going to agitate a lot of people, and I may lose some friends over it. But I have the right to feel the way that I want to feel. And if this is corruption and there is a cover-up, then the people that are responsible for this, law enforcement or not, need to be held responsible, because this cannot happen. This cannot happen. By the way, Mary, snowplow guy came through and plowed that neighborhood, did not see a body the entire time that he was out there. I think he reported the last time that he went by the house, I think it was 3 o'clock in the morning. Turtle Boy knows a little bit more on that because he actually interviewed the guy. And the thing that's funny about it is right after Turtle Boy found him and interviewed, I think his name was Lucky something, he ended up talking with that guy. The Mass State Police tried to charge Turtle Boy with wiretap because Turtle Boy has a really great photographic memory when he talks about things and reporting, that they said that he wiretapped that guy and got a recording of it without telling him, which is illegal here in Massachusetts. And they're trying to charge him now with wiretapping. And they actually interviewed the plow driver after the fact that they knew Turtle Boy interviewed him. And there's other allegations out there, allegedly, that they hid the fact that that guy was out plowing that night. And he plows for the city or the state. I can't remember. Listen, there's a lot of corruption that has happened in Massachusetts. I mean, look at, they just made a movie, Black Mass, a couple of years about it. Go about it. It happens. It happens in every system. I truly believe in my heart of hearts that, 99.999% of the system is good. There's a lot of things that do need to change. There are a lot of things that can be fixed. I'm not saying any allegations in this. I don't have all the evidence. I can't make the determination yet. But there's a lot of funny things that are going on in this case that I don't like. I don't know yet. There's just a lot of things that are questionable. All right, let's keep playing through this.
Like John O'Keefe, early morning hours, John O'Keefe was killed on January 29th,
I'm not
2022.
sure time-wise.
And the dog.
Turtle Boy will know a little bit more about that. So hopefully when I get him on the show, he can talk a little bit more about that in depth. He's been reporting on this. You can check out his blogs. If you just type in Turtle Boy, you can get his blog. And he's got a YouTube channel too, Turtle Boy Live. He does live streams every Tuesday and Saturday night at 9 p.m. Eastern Standard Time.
According to his own testimony, was inside the house and never in the front yard, which is where John O'Keefe's body was ultimately found. And the third thing that he admitted was that the dog was, quote, not great with strangers, end quote. That's a dog owner's euphemism for the dog bites, the dog attacks, the dog is mean or can be mean. So why wouldn't the Commonwealth ask about these injuries? Why wouldn't the Commonwealth inquire, as we have been inquiring, about the nature of these injuries and their significance in terms of John O'Keefe's death? It's because they know that the answer completely obliterates their case. Their theory of homicide would fold if they got the true answers to these questions. The answer exculpates Karen Reed, and the answer inculpates Brian Albert. That's because if that dog was inside the house that night, not on the front lawn, not in the front yard, but inside the house, and these injuries were suffered or sustained at the time John O'Keefe was killed, then that means John O'Keefe was inside the house when he was killed. And it also means that his body was moved. That's consistent with the facts that we also know to be true, which is not one person that was in that house and ultimately exited that house from that party that night, not one, saw John O'Keefe's body laying in the cold in the front yard. And that's because he wasn't there yet. Multiple people walked out of the house, multiple people who would have no other reason, would have no reason to lie about that. A 200-pound man, 6'2", lying in the front yard on a light dusting of snow in dark clothing. Not one person saw him. But if John O'Keefe was beaten unconscious in, for instance, the basement of that house, and later moved to the front yard after the guests had left, There's your answer as to why no one saw him. And it also answers two other questions which are looming in this case. Why would Brian Albert rip out the floor of his basement months after John O'Keefe was killed? The second question, why would he sell his house?
I'm going to tell you, there's a lot of doubt in this case. There's a lot of doubt in this case. I mean, right there, why would he rip the floor out? Why would we sell the house? There's a lot of doubt. I'm going to tell you, this defense is going to create a lot of doubt in this case. I think it's going to be very hard for a jury to convict.
So in the months following John O'Keefe's death, the dog has been gotten rid of, got rid of the evidence in the basement, got rid of the house, the crime scene itself. Your Honor, I would submit to the court that evidence is literally being destroyed right under our nose. It's been reported that the federal authorities have now gotten involved in the circumstances surrounding this case and have impaneled a grand jury, a federal grand jury, to investigate some of these circumstances. But Karen Reed should not have to wait for the feds to figure out which heads should roll. I would implore the court, now is the time for the court to take some action and give us the tools, the defense the tools that we need to fully investigate this case. We need these records to track down this German Shepherd, if it's still alive, which clearly is an open question. Our understanding is, at least up to this point, is that the dog was not only rehomed, but rehomed out of state, out of the jurisdiction of this court and out of the reach of the defense, or at least that was the attempt. We need those records to find where that dog is. If the dog still exists, we need a saliva sample, we need a hair sample, we need something. And then we need the Commonwealth to give us the tissue samples that were taken at the time so that they can be compared. This is vital to the defense. We ask that the summonses at issue for the two entities that we've described, if those summonses issue, our request clearly meets the Lampron standards. Number one, it's relevant evidence. Number two, we definitely need a subpoena or a summons. They will not provide the information without a court order. Number three, this information is necessary for our defense. And number four, contrary to what the Commonwealth constantly says, oh, well, this is just fishing, I think we've established this is not just fishing. We got a fish on the hook. We just need the court to help us reel it in. I will submit on further oral argument regarding the issues or the summonses surrounding the animal control and Canton town clerk. If the court has any further questions about those, I'm happy to answer them. If not, I can certainly give the court a preview of the second Rule 17 motion, which deals with the phone records and the actual phone of Brian Albert. But I believe the court has indicated and we've suggested that an evidentiary hearing is in order.
As I understand it, the parties have agreed for an evidentiary hearing, and we rearranged our schedule a bit so that we could accommodate you.
That's perfect.
Okay.
The only thing I would say in furtherance of that, very briefly, is the Commonwealth has suggested that Rule 17 is just sort of a regurgitation of something that we filed back in, I think it was September. That could not be further from the truth. There is new information. There's dozens of pieces of new information that we have.
What I'm going to do because of that, let's let Mr. Lally respond to your remarks on the question first.
Thank you. Your Honor, first I would state it's an interesting sort of straw man argument as far as it being road rash, or that the Commonwealth has always maintained that it's road rash on his arm. No one has ever said that, but counsel for the defendant. As far as the injuries are concerned to Mr. O'Keefe's right arm and right forearm, they've always and consistently been described as abrasions caused by blunt force trauma, not road rash. I'm not really sure where the road rash comes from.
Did you just say those happened because of blunt force trauma?
Thank you.
Yeah, I'll answer that, Keith. Yeah, the next Idaho case, because this case should be national world news. There's so much that's going on in this case, and I urge you to do some investigating of your own. This case will blow your mind. I think beyond Idaho. Beyond Idaho. And it possibly can be the next big case. It should be the next big case. Everybody should be talking about this right now. I'm surprised they're not. But people keep beating that dead horse. And I'm not trying to be insensitive here, but they keep beating that dead horse on the Idaho stuff. Got to keep getting it out there. Got to keep putting out there. There's nothing that you're going to be able to find out or figure out unless new evidence comes out or we get to trial. I urge you, Keith, go back and watch my streams. This will completely blow your mind. Completely blow your mind. All right, let's keep playing through here. I missed what the prosecutor said about the
First, I would
wounds.
state it's an interesting sort of straw man argument as far as it being road rash, or that the Commonwealth has always maintained that it's road rash on his arm. No one has ever said that, but counsel for the defendant. As far as the injuries are concerned to Mr. O'Keefe's right arm and right forearm, they've always and consistently been described as abrasions caused by blunt force trauma, not road rash. I'm not really sure what
Abrasions caused by blunt force trauma. Who cut him up? Freddy Krueger?
road rash comes from. What I would submit in conjunction with that is, again, divorcing whatever evidence the defendant claims from the context of the rest of the evidence and the rest of the case. It's a little peculiar and conspicuously clear from the defendant's fact section that the damages to the right rear corner panel of the defendant's vehicle, embedded within the bumper to that vehicle, is pieces of a cocktail glass. The victim, Mr. O'Keefe, is last observed on surveillance video, external surveillance video from the waterfall establishment that he left just prior to going to 34 Fairview, with a cocktail glass in his right hand. The same arm that's injured, the same type of glass that is then recovered from the bumper of the defendant's car. As the court is well aware, and I just stated for the records, under Rule 17, the defendant has the burden, or the moving party has the burden to establish that the documents are evidentiary and relevant. Secondly, that they are not otherwise procurable reasonably in advance of trial. Thirdly, that the party cannot properly prepare for trial without such production and inspection. And fourthly, that the application is made in good faith and is not intended as a general fishing expedition. The issue that the Commonwealth takes with the defendant's request as it applies to these particular records is with number 1 and number 4. The Commonwealth would submit that the showing from the defendant is simply insufficient to establish any relevancy or evidentiary value to these records. And then secondly, that this is the very epitome of a fishing expedition.
I'll be on it, Minnesota.
The indication, even from the verbiage that's used by counsel in the motion, sort of sheds light as far as as I just stated, the sort of epitome of a fishing expedition. It's language such as "it could shed light," or "if true, this fact would undermine the prosecution's entire theory of the case." There have been a couple of theories that are stated within the context of counsel's motion. I can state for the record, those are not the Commonwealth's theories. No one ever said that the vehicle struck Mr. O'Keefe in the head and that's what caused the injuries. That's actually not at all what the grand jury testimony or the evidence has shown throughout the course of this investigation and throughout the course of this case. But those could and if true, those very words by definition evince the very nature of this particular request. The first issue would be with the time frame, as it's stated within the motion.
There's no injuries on his body. If that car hit him and backed over him, why is there only skull fractures? There's no busted ribs. There's no busted legs. There's no tire marks on him. He's got bruises on his fist. He's got multiple skull fractures, a cut on the back of his head, and 2 black eyes. All upper body injuries, face, eyes, a fist, like when you punch someone, when like a fighter's fist after, they got bruising on their fist. I was talking about earlier when the Boston bombers, when that happened, the Boston Marathon bombers, and those two psychos were driving around, and one of them got into a car and actually ran over his brother with an SUV to get away. That guy literally had tire mark that went through his body and essentially split open his chest cavity, and he had bruising and burn marks all over him. So why is there no body injuries and you got scratches on his arms? And there's a dog in the house, but the dog's not there anymore and they don't know where the dog is. It just doesn't make any sense to me. A lot of weird stuff.
2015 to present. I'm not sure why so expansive a time frame is needed or necessary or relevant to anything that is a subject matter before the court. As counsel suggests, that photographs of Mr. O'Keefe's injuries suggest that he was severely beaten and left for dead, having sustained blunt force injuries to both sides of his face as well as to the back of his head. That there's evidence of defensive wounds. There's a cluster of deep scratches and puncture wounds to his upper arm and forearm. And then the defendant essentially asked the court to take the then inferential leap that these injuries, which are wholly inconsistent with the injuries noted by both the emergency medical personnel at Good Samaritan, when Mr. O'Keefe was taken immediately from the scene where his body was discovered, and from the medical examiner's finding and sworn testimony. So wholly inconsistent with those, that these are, then take the inferential leap that these are consistent with bite marks or scratch marks from an animal, specifically a dog. In support.
So I'm going to say this. Huss says, standing, slurring, holding a glass from the bar while arguing in ear, she lost it, put it in reverse, boom, blunt force trauma. Okay. 62 feet. This is not me stating this. This is what the prosecution said. 62 feet. And I showed earlier what it looked like that night outside the residence. So let me show you that picture again if you didn't see it. "62 feet. Hang on. "62 feet. In these conditions, 62 feet out, right up here, right over here. So measure out 62 feet. 62 feet in these conditions, backing up at 24, 25 miles an hour on a street that curves and just nails him. And he goes flying 12 feet over a snowbank. There's no way that's possible. I've lived in New England my entire life and driven in snowstorms. How are you backing up? Even if it was 2 feet of snow, there's no way that you could do that. And I just showed a video this evening at the beginning of the podcast where someone literally went out there and backed up 62 feet, only made it 19 miles an hour and 62 feet on clear roads, and couldn't even get up to 24 miles an hour. The road curves there in a blizzard. This is what the conditions were that night. You're looking at it. This is when the cops arrived. Your car would be spinning in that snow, backing up. Believe me, I've driven front-wheel drive cars in snow my whole life. I have a four-wheel drive car now, but when you gun it, your tires go whoosh. If I was to gun it in that, trying to back up, my tires would slip. And then you're going to tell me that O'Keefe's just going to stand here, way over here, and go, okay, yeah, I'm going to wait for this car to back up 62 feet and hit me. I'm just going to decide to be hit tonight. Doesn't make any sense. Doesn't make any sense at all. So, food for thought, JD. I might not be as eloquent describing it, but that's what I see.
According to these assertions, as counsel stated, there's an affidavit from Dr. Frank Sheridan that the injuries are consistent with animal claw or scratch mark.
Yes, it's exactly where he went, exactly to the spot that the prosecution said. They measured out 62 feet. He did the experiment on clear roads, and he couldn't even get up to 60, 24 miles an hour. What's going on here?
As far as
There we go.
how the medical professionals detail what those injuries are. In those medical records, what the personnel at Good Samaritan, the doctors, the nurses who examined Mr. O'Keefe when he came into their facility, they describe his injuries as a right superior orbital ridge region, approximately 7 millimeter laceration, positive for surrounding soft tissue, swelling.
Oh shit! I'm not sharing my screen. Sorry, guys.
Caused by a blunt
Sorry about that.
object. She described or noted that they appeared to be in a linear pattern. She detailed that she observed no signs of an altercation or fight from her thorough internal and external examination of Mr. O'Keefe. And lastly, she testified in great detail as to the swelling of his eyes being related to the fractures in his skull and how those manifested into the observable swelling and discoloration of his face. And essentially what she testified to.
I don't know, Regina. That's what the state came up with. That's their statement. 62 feet out, 24 miles an hour. That's what their prediction is. And that's where Karen Reed hit John O'Keefe. John O'Keefe got hit, flew 12 feet over the snowbank into the snow, and that's where he lied to die and got all those injuries from being hit. I'm going to tell you, if that car was coming at me, and let's just say I was standing there and I let the car hit me, it probably would knock me back 3 to 5 feet. I'd probably bump my head on the pavement, but I would get up and I'd be okay. I'd probably have a concussion, but I don't see how that car would hit you and you would go flying over and you would have 2 black eyes. Your skull would be all fractured, a big cut on your head, all these abrasions on your arm. Because if you're just standing there, the car is going to be level with you. It's a big SUV. The car is going to be tall. If you get hit, it's going to hit you. You're going to bounce off. You're not going to just fold under the car and someone's. If that was to happen, let's say he did fold under the car. Why is there no injuries on his body? There's no injuries like a crushed leg or a crushed arm or a tire mark on the arm. Nothing. There's no tire marks on his clothes. Nothing. No grease. No nothing that would be underneath a car. So I don't know. It just doesn't add up.
There was a laceration on the right back of Mr. O'Keefe's head. There was a skull fracture in that immediate area, the right parietal area of the victim's skull. That then caused a swelling on the brain, which she observed, as well as Dr. Stonebridge observed during her neuropathology examination of Mr. O'Keefe's brain post-mortem. That then caused the swelling underneath of the skull, caused the radiating skull fractures that she observed in Mr. O'Keefe's skull throughout, and that the essentially nowhere else for the blood to go, and the looseness of the vascular tissue behind the eye then causes both of the eyes to swell. There was no evidence that Mr. O'Keefe was beaten and left for dead. There was no evidence of any defensive wounds. She was specifically asked those questions and testified to that.
Sure.
Before the.
I'll give you that. But they said there was 2 inches of snow on that ground. So actually, it would have actually helped Karen. So let's say that her view wasn't obstructed that night. Her senses all would have went off. She would have known. And then you have a witness that drove by and saw her sitting there, and John O'Keefe was not in the car. He wasn't even around the car. So that would tell you that he went into the house. There was 2 inches of snow. You still can't back up in a straight line with 2 inches of snow on the ground. I'm telling you, get out there. If I don't know what area you live in the country, wait for a snowstorm. Go measure out 62 feet on a curved road and try to back up in a straight line. And why would anybody just stand there if a car was backing up? And I mean, it's gonna take you 5 to 8 to maybe 10 seconds. I mean, I don't know. I'd have to time it out. Maybe 5 seconds, 3 to 5 seconds to back up, to give you reactionary time to get out of the way. You're just going to stand there and let a car hit you? Doesn't make any sense. Doesn't make any sense.
Grand jury as to those injuries and how they sustained. There's absolutely no evidence that Mr. O'Keefe ever entered the residence at Fairview on that particular evening. Counsel mischaracterizes some other statements made by a witness, Mr. Brian Nagel, who had come to pick up his sister at the residence. She came out, he observed that vehicle. He observes that vehicle from the entirety of the time that he's there. So he's pulling on to Fairview. Ms. Reed is coming on to Fairview in the opposite direction. The right blinker on and a left blinker on. The operator of the vehicle that Mr. Nagel is in.
Why do I keep changing my voice? That's one of the most oddest questions I've ever heard in my entire life. What are you talking about? I'm changing my voice? What are you hearing? Are you hearing voices in your head? What are you talking about?
Pull in first. So Mr. Nagel is there the entire time that Ms. Reed pulls onto the street when she pulls up. Indicates that she initially pulls over to the right-hand side of the curb, then pulls the vehicle forward a little bit further. That's corroborated in testimony from a number of different people who were inside the house, as well as Mr. Nagel's sister, who then came out of the house and talked to her brother at the door of the truck that he was riding. Mr. Nagel further indicated that at no point did the brake lights come off, including the center top light of the SUV that he observed in front of the house. There were no footprints outside of the vehicle. He never saw anyone exit the vehicle. No one in the house reported ever having anyone come inside the house or seeing anyone exit the vehicle. And I'm a little confused just as far as counsel's statements, as far as the multiple people saw Mr. O'Keefe or never saw Mr. O'Keefe come into the house. Or if he comes into the house and he's attacked by the dog, I'm just a little confused as far as are they in the conspiracy, or are these people sort of let out of the conspiracy because they say something that doesn't further that conspiracy? If they're all in the house and Mr. O'Keefe comes in the house and gets attacked by a dog and then gets dragged out to the bottom of the lawn and left there for dead, then why do they all testify that no one came into the house? It's consistent throughout the entirety of all the witnesses. It's consistent with Mr. Nagel as well. It's consistent with the forensic evidence. It's consistent with every piece of evidence that has come to light at this point. And there's further statements in regard to the dog. Some reported incidents several months after the death of Mr. O'Keefe. The counsel suggests ineluctably that the animal was violent and prone to violence from one incident that postdates this particular time frame of Mr. O'Keefe's death, and seems to punctuate that this circumspection on and on about how violent the dog is from an incident that he has no information about, whether or not it involved another animal, whether or not it involved another human, whether or not it involved what exactly the incident occurred. This is simply not what Rule 17 is to be used for. That's what the case law has consistently held, is that it is not a discovery tool. It is based on information, relevant evidentiary support, which is completely and utterly lacking in this particular motion, in this particular submission. So for those reasons, the Commonwealth would request that the motion be denied.
Okay. So the second Rule 17
That's what I'm trying to get at. That's what I'm trying to get at, Regina. Exactly.
motion.
Just cannot happen.
We're going forward on that and then having the
Thank you,
hearing
Teresa.
regarding the timing of the video. How are we going forward with this before I hear from you on the substance, Mr. Jackson? What is the next date for?
May 25th.
Right. What's it for? The evidentiary hearing?
Yes.
All right. So do you plan on arguing your Rule 17 motion today or that day? Not both?
That day.
Okay.
I'd rather reserve and
That
argue
makes sense
the
to
17th that day.
That makes sense to me as well. So we're finished for today, unless there was any follow-up to Mr. Lally. I'm
There
not
is.
going to hear a preview on the motion that we're going to hear on that day.
That's fine. I do have some points to make.
Okay, I'll hear you on that.
Thank you. With regard to the dog, first of all, I think the Commonwealth misses the point. If there was a fight inside the house with the dog's owner, the dog would likely attack. That is the idea that is borne out by the evidence that we have. We know that he was beaten. We've got evidence that John O'Keefe was beaten, that he lay there unconscious. And we also have evidence that at the time he was beaten facially and blunt force was used against the back of his head, he was also attacked by an animal. Well, Brian Albert, who's a known fighter, owns a 90-pound German Shepherd that has since been gotten rid of and had a skin-piercing incident as the excuse for having gotten rid of him. So we know that the dog attacks, according to sort of uncontroverted evidence. We weren't saying, we don't suggest that the dog killed John O'Keefe. We're suggesting that the dog was there when John O'Keefe died and also attacked John O'Keefe. That's the point. This is the first I've heard of the Commonwealth's new position after, 15, 16 months, that somehow John O'Keefe was stabbed or cut up with a broken cocktail glass, which would produce...
Listen, I'm from Boston. I don't know why people keep saying, like, I'm changing my voice. This is the fucking accent that we have here. Go to New York, they have a New York accent. Go down south, they have accents down there. This is... We park the car in the Harvey garage. I mean, I don't know what else to tell you. That's how we talk here. So you must never hear anybody from Boston if you're asking me that I'm changing my voice. I've talked like this the entire time that I've been on air. I don't know what these people are talking about. And then they come in and they go, T-Rev's stealing the thunder. I don't even have time to watch T-Rev. I don't watch T-Rev. I know of T-Rev. I don't have any issues with T-Rev, whatever. I mean, I don't watch other true crime channels. I watch and pay attention to my channel to have my own material on here. I don't keep up with the Joneses. I really don't care what anybody else does on their fucking channel. I know the channels, what they do. I know the content that they put out there, but I can care less. There's a lot of channels that go out and just put conspiracy shit out there to get clicks and views. If you want to follow that crap, hey, go for it. You know, don't let these people fool you. You know, they don't really give a shit about any of this. The bottom line is they can care less about it. A lot of these people that jump on this have a dark past. They're not productive members of society. They don't go out and work full time. They sit home and collect by on means. They don't take care of their children. They're wrapped up in there. A lot of these people have criminal records that are in these true crime genres. I want to see some of these people getting up and being productive in society. Do you go to work every day? No, you sit home, you do drugs, you drink, you trash cops. You trash the system, you trash society, you put yourself implicated in highly publicized cases with talking to witnesses on your panel. I don't give a shit if they sat there and talked about climbing fucking trees. You have a person that's active in a very, 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 very important murder case on your panel. They shouldn't be fucking there. And then these people that come late to the game and they insert themselves and say, oh, I did all this research and I'm going to follow around the escaped criminal. And all of a sudden you have 12, 15,000 views on your channel watching you live. It's impossible. I started covering the Danilo Cavalcante case before people were even down there. Nick the Hat was the only person that was down there, boots on the ground. I was streaming his. The most people I ever had in my chat during the live was 800 people, maybe 850. Then all of a sudden you come in like 5 days late to the game, you start streaming live and you have 15,000 people watching you. Impossible. So don't let these people fool you with their fake views and their fake subscribers and their fake live streams. We know all about it. John and I know about it. John's looked into it. He has the people that have come out and talked about all this stuff, all the bots they use. You know, look at here tonight, 71 people, but I've had streams where I've had 300 people, 200 people, 100 people. That shows you a wave. But then when you start watching these lives on other channels and consistently every night, there's 5,000 people watching them, 2,000 people watching them. It's virtually impossible to happen on YouTube. You can even watch channels that have 100,000 subscribers, and they'll maybe get a percentage of that watching them in a live. So don't let them fool you. They don't care. Most of these people are criminals. Most of these people have criminal records. Most of these people sue people for bullshit, that just to sue people.
These injuries? That makes absolutely no sense. It just doesn't pass the sniff test. These are not from a cocktail glass.
These people are drug addicts. They have family members that are in jail for really nasty stuff that I don't even want to talk about, like nasty stuff. They use your money, the donations that you get, that they get from their live streams, and turn around and do criminal things with it. We all know about it. People call them out all the time. John gets emails. I get emails. We know what's going on. These people don't give a shit. They don't care. All they care about is getting you in there and tricking you and getting your money. And they ask for money all the time. I do one talk during my show, if you want to. And I only talk about memberships. If you want to join a membership, I'll do it one time during the show. But these people constantly ask for money. Money this, money that. Like the other guy. What's the other one there? The preacher that is all of a sudden this true crime enthusiast, and he's going to get the truth out there, but constantly on his lives, constantly on his videos. Give me money, give me money, give me money, give me money. I need that money. Oh, Idaho, I'm so interested. I'm so interested. It's fake. They don't care. There's no compassion. All they care about is making sure that their live streams go up and they get your money. All right, let's keep playing through.
Who did that to him? Is there new theory that Karen Reed got out of the car, broke a cocktail glass, then wielded an edge of that cocktail glass and cut up John's arm? Then John stood there while she jumps in the car, slams it into reverse, then hits him with the car, with her taillight in the back of the head. It makes absolutely no sense. That is the Commonwealth grasping at straws.
JD's right.
If it walks like a duck and talks like a duck, it's a duck. This looks like an animal attack because it is an animal attack. And it's at the same time, temporarily at the same time, that he was otherwise beaten and then ultimately left for dead.
I can guarantee you this. As much money that I have in my channel, I give out all the time. I give free memberships out all the time in these chats, just about every stream. So that's $25, $25, $25, $25, $25. You know, that adds up. When I do the giveaways, we give away a couple weeks ago, I gave away a Michael Kors, a Marc Jacobs tote bag, $195 value, free to viewers. That shit costs me money. I got to pay for that. These creators don't give back. They don't honor your super chats when you open your wallet and donate to these channels. They're not pulling up live and saying thank you. They don't care. They don't give back to their communities. So don't let it fool you. Don't let it fool you.
Interestingly, it's interesting that the Commonwealth doesn't mention the basement in their arguments. I mentioned the basement because that's very likely exactly where John.
Well, the reason we got on the focus, Nancy, is because people like to come into my chat and they like to talk about other people, saying that they're doing so much better than me. I really don't care. That's the thing. I don't care. Why come in and disrupt the productive chat that we're trying to have here and focus on a case that's very, very important? But see, they got to come in and try to shake up the room and shake up the subscribers, the people that really care and they want to be here. It's easy. You just don't have to do this. Just don't watch. Push aside, go watch the streams that you want to watch. I have no problem with that. You just always click the off button. But I do this for all of you because I don't want the chat room to be disrupted. We're trying to get through a case. We're trying to understand the facts. We're trying to weigh our opinions on what way we go back and forth. I really don't care if someone has 50,000 subscribers. I really don't care if they get 1,000 million people watching them live every night. All I know is that I have to take care of LTL. That's the most important thing here. So we'll get through this. Let's finish this, and then we'll say goodnight.
O'Keefe went once he walked into the house. There's no evidence that John O'Keefe walked into the house. The Commonwealth has evidence that John O'Keefe went into the house. They haven't. They just sat on it for several years, or for several months, over a year. That the Apple Health data from John O'Keefe's own phone.
This is important. It's important. Listen.
Establishes that once he was at the location at 34 Fairview, he climbed 3 sets of stairs. The Albert house happens to be 3 floors, a basement, a middle floor, and an upstairs. His Apple Health data also shows that he took multiple steps after he left the car, after he left Karen Reed's vehicle. The multiple steps indicate that he was in the house. If, in fact, the Commonwealth were correct, and he stepped out of the car, was hit by the car, and fell down and died. If that's what their theory is,
1999.
He would have no Apple Health data.
Thank you.
Suggesting that he was climbing stairs and walking about as if he were inside the house and was ushered down to the basement, at which point there was a fight, he was beaten to unconsciousness, and then everybody in the house leaves, not having to go down to the basement. There's a door that services that basement that's closed. So there's no reason for people who are upstairs, either upstairs or on the main floor of the house, to even know that there had been a fight downstairs.
Thank you so much.
Or that John O'Keefe never made it out of the house.
Just going to go back and recognize these. Let's read these out. Cindy says, just because I support you and love your podcast. I think it's supposed to say that. Thank you, Cindy. I appreciate you. Minnesota with a 20. And I choose to whom I support, and I support you for real. For real. Thanks for all you do in keeping it real. Thank you, Minnesota. Thank you for being here. I do appreciate it. Thank you. All right, let's keep playing through here.
Alive.
Late night tonight. Sorry, guys. I had a lot to get off.
With regard to Ryan Nagel, the Commonwealth leaves out probably the most important part of his testimony. Ryan Nagel's testimony is that he arrived just after Karen Reed arrived. They arrived not at the exact same time. She turned down the road. Then he turned down the road. As he approached the road, as he approached the house, he then pulls to a stop. He had her car in his sights the entire time, just after she had already arrived. Certainly time enough for John to get out of the car and walk toward the front door. He said that he observed that there was no taillight damage whatsoever. He later observed inside, either through a dome light or through other ambient light, that he could see inside the passenger compartment of her car, and that she sat there alone. And most important, he didn't see her hit anybody with her SUV. That's the most important part of Ryan Nagel's testimony. He didn't see her hit John with the car, which he would have had to have seen if he was situated right behind her. And the Commonwealth has repeated what they've oft repeated several times, which is there was no sign at all of any kind of an altercation or fight. Well, if there's no sign of an altercation or fight, how can you turn around and say that a cocktail glass did this? They can't talk out of both sides of their mouth. How could they reasonably ignore 2 black eyes, a laceration over his right eye, a laceration at his nose? He looked like he had gone 10 rounds with Mike Tyson, as my colleague has once analogized. Of course there's evidence that he was in a fight. The back of his hands, deeply bruised. Those are called defensive wounds. I don't care what their medical examiner called it. Anybody who's seen any sort of a fight, a street fight, knows that the back of the hands, the back of the arms get the brunt of the punches as you cover your face. Of course there were signs of a fight. Not just a fight, a brutal fight. And what does a dog do when its owner is in a fight? What does a German Shepherd do when its owner is in a fight? Reaches out and attacks and supports his owner. And what does a person do when a dog attacks? Usually puts his arm up, his dominant arm up to protect himself. And that's where the lacerations, the bite marks, the claw marks appear on John O'Keefe's arm. This is not a fishing expedition. The Commonwealth has an unreasonable expectation. They cite to words that we use what the evidence might show, or what it could show, what it potentially will show, as a weapon to say, well, see, they don't know what the records are going to show. Well, if I knew what the records are going to show, I already have the records. I wouldn't need the court to ask for them. Of course, I don't know everything that's in the records. And the reason that we asked, Your Honor, for 2015 is because we have evidence that in 2017, the dog looked full grown. So we wanted to go back and bracket the proper amount of time. If say the dog was a couple of years old at the time that photograph was taken in 2017, we want all the records associated with that dog, which means we bracketed our request. It's not overly burdensome. It's certainly not burdensome to the Canton Animal Control, and it's not burdensome to the Canton Town Clerk. And if the records don't exist, because they just don't, they're too old, then no harm, no foul. But that's why we bracketed our request to go back from 2015 to present. And with that, Your Honor, I believe that we have made a good faith showing. We have met the standards of Lampron, all four standards of Lampron, and the summonses should issue. And also,
All right. Anything else, Mr. Lally?
Just briefly, Your Honor, as it pertains to, Commonwealth would agree that attributing the cuts on Mr. O'Keefe's arm in their entirety to cocktail blast would be somewhat ridiculous. That's not what I said. And that's not what I was attributing them to. I think the court understood that, but just so counsel understands that as well. As it pertains to Mr. Nagel, what is in his testimony is that he had the vehicle. They arrived at the residence in tandem. The vehicle was there when Mr. Nagel left. So while he sees no one exit the vehicle, no one enter the house, and no one else sees anyone exit the vehicle or enter the house during that specific time frame, the defendant, and presumably Mr. O'Keefe, are still there and still in the vehicle at the time Mr. Nagel leaves the house. That was the point that I was making with that. As it pertains to the Apple Health data, and obviously we'll get into this a little bit more when it comes to that subsequent Rule 17 motion, the Apple Health data is the same Apple Health data that's being relied upon for the supposition that Mr. O'Keefe went inside the house. That same Apple Health data has, among other things, Mr. O'Keefe taking 46 steps and traveling a certain bit of distance around 11:56 a.m. on January 29th. The problem with that is that he was pronounced deceased at the Good Samaritan Medical Center at 7:50 a.m., some 4 hours prior to that. In addition to that, from the information as far as when that ascending or descending of stairs occurred between, I believe it's 12:21 and 12:24 a.m., there's a Waze search and location data from Mr. O'Keefe's phone. The Waze search is conducted, and the GPS location information from Mr. O'Keefe's phone shows him en route to the house and not arriving at the house until 12:24 a.m. So the information the counsel is relying on has him going up and down 3 flights of stairs before he's even at the house. So for those reasons, again, the Commonwealth would submit the defendant has not met its burden and ask that the motion be denied. Before we do conclude, I just did want to remind the court there are a couple of other issues that I need to address with the court, specifically the Commonwealth's motions to impound and the Commonwealth's motion for access to the defendant's phone.
Okay, I'll hear you.
So there were 2 motions to impound that the Commonwealth had filed. One pertains to the grand jury transcripts and exhibits that I had attached as attachments or exhibits to the opposition to this specific motion, and really to
Okay,
both motions.
and those are impounded by statute.
Right. The other motion to impound that I had filed pertains to the attachments to the defendant's Rule 17 motion pertaining to Mr. Albert's cell phone and the call detail records of Ms. McCabe and Mr. Albert. Now, certainly, the Commonwealth is not saying in any way, shape, or form that those items shouldn't be submitted. The defendant can submit whatever she wants, whatever counsel wants in support of that request for the court to review. But the manner in which the information is released, and specifically what I take issue with, and I'd be remiss if I didn't say this on behalf of the O'Keefe family.
I'm not sure I'm not sure they hear you.
In reference to the motion to impound the attachments to the defendant's Rule 17 motion for Mr. Albert's phone and the call detail records of Mr. Albert and Ms. McCabe, I'd be remiss if I didn't, on behalf of the O'Keefe family, as well as just what the statutory rules are, and specifically I'm talking about the Supreme Judicial Court, Rule 124, pertaining to protection of personal identifying information and publicly accessible court documents, which I would imagine that at least Mr. Unetti, even if Mr. Jackson and Ms. Little aren't familiar with, does provide rules as to how things are filed that are of that kind of sensitive nature and that kind of biographical information. And they're routinely filed with the court with a motion to impound or a motion to seal and not filed directly with the media. The issue being that there are photographs depicting Mr. O'Keefe's postmortem at the Good Samaritan Medical Center, as well as possibly some autopsy photos that should have been impounded. There are unredacted Canton Police Department reports, multiple copies. Again, not anything that Commonwealth takes any issue with the court reviewing, but as far as them being made public with those witnesses' names, dates of birth, social security information, addresses, phone numbers, things of the like that should be impounded pursuant to the statute as well. And in particular, I do take issue with that motion, specifically on page 11. There is a specific reference made to the name of the decedent's niece, which is strictly prohibited as far as being provided in a public document. So for those reasons, I would ask that the attachments to that motion, to whatever extent it can be at this point, given the public release of them, be impounded.
Mr. Unetti?
Your Honor, I believe that some of that information may be in the public domain already, so it may be that the cat is out of the bag with regard to some of it.
It is now, right?
I'm sorry?
It is, the cat's out of the bag now.
Right, yes. So, I mean, we're agnostic on this motion to impound. We have access to it, the Commonwealth has access to it, and most importantly, the court has access to it.
All right, so by statute, everything that was raised by the Commonwealth was supposed to have been requested to be impounded at the time it was filed. So that was not done.
Are you talking about the motion that we filed with regard to the Albert phone motion?
Yes, the attachments. Mr. Lally just outlined it.
I don't think that there were any grand jury minutes attached to that motion.
No, that was a separate motion that Mr. Lally just filed on behalf of his motion.
Right, and we don't have
when he was taking issue with the defendant had filed.
Right. Okay. Yeah. Again, we don't have an objection at this point.
All right, Mr. Clerk, those are both allowed. All right, is the hearing? Those are both allowed by statute. So, is this hearing over?
Your Honor, if I could just address, the Commonwealth had filed some time ago a proposed procedure regarding communications stored in the defendant's iPhone. So we had addressed this briefly, I think, on the last court hearing date in February in relation to the defendant's phone. So the defendant's phone was seized lawfully from her pursuant to a search warrant. The information contained therein was then downloaded. Upon a cursory review of that information, there was an indication that there was some communication between Ms. Reed and Mr. Unetti contained within the information within that phone. So obviously all examination of Ms. Reed's phone from the Commonwealth's perspective ceased at that time. And we had begun exploring and filing this motion. I had it in hand to file with the court on the last date. However, after several discussions with Mr. Unetti and counsel for the defendant, I was then informed in court on the last date that the AFE or the independent sort of forensic examiner that would look at that phone was believed to have some sort of conflict. It was not acceptable to Mr. Unetti. So there was a separate person who essentially runs the lab at the Attorney General's office, who I spoke to Mr. Unetti about whether or not that person would be acceptable. He does have a conflict, just so the court is aware, as far as grew up in the same town as the victim and his siblings. But Mr. Yannetti indicated that he, at least verbally to me on that date, that he didn't see any issue with that conflict, as the person would just be assigning it to a couple different forensic examiners within his office. I then modified the motion to incorporate that subsequent AFE, sent a copy of the motion to council 6 weeks ago or so, and still have received no response. So what I'm looking for today is action on that. The other thing that I would note for the court is that council had asked for a raw extraction copy of the material from the defendant's phone, which was then provided to council on March 22nd. So for over a month, the defendant has had access to the defendant's phone and the Commonwealth has not, because counsel has failed to respond to whether or not the AFE was reliable or not. And what I was referencing on the last court date is the court had indicated that if we were to come to some sort of agreement, the court could act on the papers and obviate the need to address it on this date. It hasn't happened. I would submit that the proposed protocol was more than reasonable, and I would ask that it be allowed by the court.
So, Mr. Yannetti?
Yes. I was the one to suggest that it be analyzed by the Attorney General's Office, Cyber Crimes Division. I thought that that was clearly, we have no objection to that, but I'll announce it in open court. We have no objection to that. The motion for the protocol, procedure is agreed to.
And you're okay with the individual that was cited in it?
Yes, the individual who was cited in it is the head of that unit. I know who he is. I respect him. He revealed to me at the start that he has a personal conflict. I have no issue with him assigning it to somebody in his office.
Okay. So the motion's allowed by agreement?
That's fine.
Okay.
Thank you.
Clerk? Yes. Motion's allowed by agreement.
Just one other thing. Mr. Lally had mentioned to me, and I don't know if he still intends to be heard on this, but there was an issue of exhaustive testing that I thought.
He argued that a while ago.
Okay. And was that acted upon by the court?
He said he was waiting to hear back from you where we stood on that.
Right. So with regard to that, Judge, we're all for exhaustive testing as long as we can have our expert present at the time.
So Mr. Lally, would you explain to it? Would you say again what you explained to me?
Certainly, Your Honor. So there's a form that's provided by the lab that I then provide to counsel. In this case, in any case, that where exhaustive testing is necessary and the sample would be subsumed within the analysis. So I provided that to counsel. I just simply need counsel to execute that form, indicate whether or not they want someone present and who that person is, what their contact information is, and then I'll provide it to the lab. The lab will then contact their expert and schedule a time for the testing to be done.
Okay. We're happy to do that, but my understanding from Mr. Lally's earlier argument is that only applies to the hair that was found on the car. That was not part of any motion that we had today in terms of a motion to compel. What about the other evidence with regard to the tissue samples and everything else that we actually asked for in our motions today?
Is there exhaustive testing on any of those items, Mr. Lally?
Not that I'm aware of.
Okay, fine. Yeah, so we'll sign regarding the hair. We're not concerned about that.
Okay, is that everything?
From the Commonwealth, yes.
I believe so, Judge. Thank you.
All right, thank you. We'll see you on the 25th.
5:25 at 9:30, correct?
All right, that's going to adjourn that. I thought we were going to get through a lot more, but I talked a lot tonight, so I just want to see something. Let's see something really quick. I'm going to work on, like John said, work on getting some crash test dummy videos. We'll show. Hopefully I can find something in reverse, because that would be more fair to the case. It's a lot different when you're driving straight, accelerating straight at someone versus backing up. So we'll be fair. Hopefully I can find something, an SUV or something like that. So I'll work on that. I wish I had SUV because I would just do a demonstration. I would just buy a crash test dummy or something and do a demonstration. But I'm going to be back. I'm going to be out tomorrow at 34 Fairview Road. We'll get some boots on the ground. I'm going to do a live from there tomorrow, spend some time in that neighborhood and walk around, give you all a firsthand look, a live look at what that location looks like. And I want to get down and show the curved road in the area where they unfortunately found John O'Keefe passed away. So I think it's important to get out there. Maybe I run into someone that wants to talk about it in the neighborhood. I doubt it, because I think a lot of people are really, really shook up about this case. It all remains to be seen. My eyes are wide open on this. I just want to keep putting things out there for people to think about. And hopefully next week, I'll have Turtle Boy on. So I'm in conversation with getting him on. You'll get kind of his take, and he's very strong in support. I'm going to warn everybody right now. He is very, very strong in the support of Karen Reed. He's done 6 months of a lot of investigating into this case. I think it's good to hear what he has to say. He's an award-winning journalist. So I think it is good to hear what he has to say and talk about in this case. I have a lot of questions for him, and I will prepare for that live really well and have some great questions. And maybe I can have you all email in some questions. I can't guarantee that we'll ask all of them, but I'll pick some that may be very relevant or something that, maybe we can ask him. So let me keep working on that. Again, we had some communication today. We're just trying to set up a date and a time, and I'll let everybody know. But I'll be back tomorrow during the day. I think I have the stream for 12 noon. I may do it a little bit earlier. That would be 12 noon Eastern Standard Time. I'll be out at 34 Fairview Road, streaming live from there, some boots on the ground coverage. And then I'll be back tomorrow night at my usual time, 8 p.m. Eastern Standard Time, to do some wrap up and continue through with these pretrial motions. I think it's important to keep going through this. Sorry, these streams have been super, super long lately, but I appreciate everybody chiming in. I know on the replay to watch a 3-hour stream is a lot. So keep coming back. I'll try to shorten the streams down. I got kind of off target tonight, but there was a lot to get into, and I appreciate you all. So be good, be well, get some sleep. We'll be back here tomorrow. Wait for that live tomorrow afternoon if you can make it. If not, you can watch it on replay. And then, of course, we'll be back for the live show tomorrow. All right, everybody. Have a good night. Bye.